Quickly list item number 1.
Not audible. Adjust your mic, sir.
Sir, you are not audible. Problem na problem. You call the next matter. In this case, my copy also not served. Let him serve. He's not able to. Okay. Call the item number 2. Next item.
Item 2.
हमारी जैसे काम स्टाइल तो नहीं
He has died.
Well,
16 पेलन ना
काम पर उठाएगा नहीं करना है ये ना लक्ष्य पता है
Here use the letter dated 29/3/2023 of the Superintendent District Jail, Keonjhar, Bracket Welfare Services, in which it is mentioned that the appellant Dasarathi Naik expired on 9/2/2023 at about 8 p.m. during course of treatment in ICU of SCV Medical College Hospital, Kamakata. No near relatives of the deceased has preferred any application to continue the appeal. Accordingly, the appeal is disposed of. Yes.
Item 3.
Yes, Mr. Tripathi. The stamp reporter has pointed out that the correct nomenclature is CRLMP. One appears for the appellant Uttarlakshmi. In case an interim application is filed for change of nomenclature from WPCRL to CRLMP, the same shall be listed immediately. If no interim application is filed within 2 weeks from today, WPCRL shall stand dismissed without further reference to the bench. Change कर दो ना.
Dispose of, or it will IA.
No. He
will file IA for
when the IA will file, it will be listed
right.
for change of nomenclature.
Mala.
Then it will go to the appropriate
Mala.
bench. If
No
he
step
does-
is taken
no, then it will go.
within 2 weeks.
Yes, next item.
Item 4.
May I please understand, my lord? In this case, my lord, the petitioner prayer is there, though the son of the petitioner died on the 4th March 2000. Till today, the one statement of the informant is not recorded. For that reason, my lord,
The perfunctory investigation, inaction of the police, whatever it may be, that comes within the jurisdiction of that. That will nomenclature is CRLMP. So
Well, I
file
have-
an IA to just same order like देवे and defects to be removed within it is non-obvious defects as part of the stamp reporter to be removed. है ना? IA to be filed for change of nomenclature within 2 weeks. है ना?
my lord, may I submit one thing?
Yes, next.
My lord, one thing, my lord. My prayer is to hand it over the investor to other, my lord. Though, my lord,
That cannot be within the purview of WPCRL. WPCRL is exclusively for habeas corpus. Okay.
yes,
So
yes.
that prayer can be adjudicated in a CRLMP application,
Yes, sir.
which obviously would come before a single bench, right?
Yes, my lord, I will file.
But just to file an interim application for change of nomenclature from WPCRL to CRLMP.
My lord.
That's all. And there are some 4 to
Def-
5 other defects
defects,
that
yes.
also you remove. Within 2 weeks, we have granted you.
Yes, my lord.
You, Mr. Tripathi, that order is it a non-appeals category?
You are given 2 weeks time to file application for change of nomenclature.
Item 5.
Already rescued.
Pass on the instruction which you have received.
This is a case of 2020.
No, we
But
just
now recovered after 3 years. Rescued after major. Well, having a daughter
has been handed over to the or
no, not
staying
that.
with the family.
Major there he is living with his husband.
But, the Land Council non-appeals for the appellant, the Land Council for the state has produced the written instruction received from IIC Tigriya Police Station dated 15/1/2024, from which it appears that the victim has been rescued, and since she has attended age of 18 years, unwilling to return to her parental house, she was allowed to go from the police station, and now she is staying with her husband, Ranjan Behra. The writ is taken on record. The WPCRL is disposed of. In view of such report, no further order is required to be passed.
Well, I will make a mention. Am I now audible now?
Yes, Mr. Mishra.
That item number 1, my lord.
Mr. Mishra, the London State Council submits that he has not received the copy of the WPCRL. So we'll take up this matter tomorrow.
No, copy I have given, I have received. Copy I have given, receipt I have filed along with your lordship's copy.
But he has stated that.
I have served copy. That is with your lordship's record. Copy served to this state and receipt filed.
All right, then we'll take up this matter tomorrow because the file is
Yes,
not
ma'am.
available.
Quite well.
From this weekly list, we'll take up matter tomorrow.
Yes, right, ma'am.
It will be
Right.
listed and the first item it will be taken up tomorrow. Okay.
Right, ma'am.
All right.
Much
Yes.
obliged. Copy is given.
The receipt is there. You will source it out. Yes.
Ma'am. I'm sorry because there is light disturbance. There are a lot of communication.
Sometimes it happens, Mr. Mishra. Sometimes it happens. Yes.
Well,
Item 6.
Items. Item 6, I pray for Thursday. Thursday. So 18th January. Okay.
Item 7.
Yes. You have given a copy of this report to the Land Council for the petition or not? So you have collected the name of the officer and her designation. What is the age of the victim now?
16 plus.
16 plus. That boy is a co-villager or co-villager? What he was doing? Poor. Se ପିଲାଟା କଣ କରୁଛି?
Sir, accused in this case is study, sir.
ପଢୁଥିଲା.
Sir,
Mr. Das, the last occasion we observed in that order that boy has filed a application under section 482 CRPC for quashing the criminal proceeding, and no interim order was passed. Any development made in the meantime in that CRLMC? Have you got any? No, my lord, I have not. Have you checked off the this? ଦେଖିବେ ନା ଆମେ କୁହନ୍ତୁ ଆଉ ଲିଷ୍ଟ ହେଇଥିଲା କି ନାହିଁ? एका कॉलेज रे पढ़ुथिले?
No, sir.
No, you said that the boy was also a student.
Sir.
झियो कौन पढ़ुथिला पुओ कौन पढ़ुथिला?
Sir, ଝିଅଟା ଜୁପିଟର କଲେଜରେ ପଢୁଥିଲା +2 ଫାର୍ଷ୍ଟ ଇୟର।
First to first year.
ସାର୍
ଆଉ ସେ ପୁଅ?
ପୁଅଟା ମହାରାଜ କଲେଜ ବ୍ରହ୍ମପୁରରେ ସାର୍ ITI କରୁଥିଲା ସାର୍।
ପୁଅର ବାପା କଣ କରନ୍ତି?
ସାର୍ he is a farmer.
No order is in past matter for 7/7/2023. Yeah, as it is. ये केस कनेक्शन रे एजी ऑफिस तरफ रो किछि जो दीटा पेंडिंग अछि केस तारे किछि केस डायरी मगालाणी?
ହଁ ସାର୍ ଗୁଲୁ ଚମ୍ପତି ଜଣେ ଫାଇଲ କରିଥିଲା ସାର୍ ଯୋଉ ସସ୍ପେକ୍ଟ ଥିଲା ମୋ କେସରେ। ଗୁଲୁ ଚମ୍ପତି
प्रताप केसरी
ପ୍ରତାପ
चंपती
କେଶରୀ ଚମ୍ପତି ସାର୍।
तारी ना गुरु चंपती
ହଁ ସାର୍
जोड़ा एंटीसिपेटरी बेल फाइल करछि जो इंटरिम प्रोटेक्शन दिया आइछि
ସାର୍
से केस भी पेंडिंग अछि किछि?
ସାର୍ ସାର୍ କିଛି
You want some further time?
ସାର୍
All right, dear. As per the order dated 11/12/2023, Anjali Shah, SI of Police, Chandanpur PS is present. And the Lieutenant Counsel for the state has filed the status report submitted by IIC Chandapur Police Station dated 16/1/2024, in which various steps taken for rescue of the victim, also to arrest the accused, have been highlighted. Copy of the status report has been furnished to the Lieutenant Counsel for the petitioner. Status report is taken on record. Anjali Shah, so you are the investigating officer, no?
Sir.
The investigating officer of the case. She seeks some further time to carry forward the investigation put of this matter in the week commencing from 19th February. 19th good 26th. 26th February 2024. The Lieutenant Counsel for the state shall obtain up-to-date instruction in the matter, so also the development, if any, made, and submit a further status report. Personal appearance of the investigating officer is dispensed with. Yes.
Item 8.
Yes. Put him dispense with the मैडम आपनकर पर्सनल अपीयरेंस डिस्पेंस हुई थी तो आपन कोन पे आसिले दरकार थिले जदी दरकार ही थांदा सी डकी थांदा आई विल सिस्टर बिकॉज़ नॉट येट दिस टू गाला नॉट येट बिन आपन डकिल रे तांको सी पर्सनल अपीयरेंस आमे तो किछि निर्देश देइ नतुन ना डिस्पेंस हुई थी तो आपनकर ये अछि आपन डकी पाइ वी हैव will not note down his her presence, that is the thing. कौन हला कौन तो डेवलपमेंट कौन हला सुपरविजन एसपी सुपरविजन करचंदी नॉट येट द गाल इज नॉट येट बीन रेस्क्यूड मैडम have given both the supervision report as well as the investigation report by the
Now he has taken the charge. No? And now IAC has taken charge of the investigation.
Mr. Tripathi, have you got this copy of the supervision report and also?
Just now,
I've served it right now.
Okay. What is the age of the girl now?
15 years at the time.
अभी का कितना होला ना 15 years old. केबे का rate है FR केबे का?
2007. Date of birth 15/11/2007.
Okay, that means he has completed 16 years.
Right.
What that boy was doing?
I was doing it some sugar things and some labor money.
So they are co-villagers. Sir.
Yes, co-village. Where about my girl is madam? I have not.
They are tracing it out. What can be done?
They are not taking any census.
Our country is not a small place, and
They are not
100,
taking any steps.
140 crores people are there. So
Cross the affair in February. After getting the notice from this honorable court, they started the
they have
and they have to file different affidavits. They have something
they have what steps they have taken that has been enumerated in the status report, and so also the supervision report both have come. And in the paragraph 13, it is mentioned that special team was also formed and to trace out this one. So, and a IPS officer with the superintendent of police, Nagar, he has also is now supervising the case. What is the last page, Mr. This is not the page. The party
seems to be incomplete.
seems to be incomplete.
Sorry, well, I'm sending. Supervision report.
Supervision report last
I'm
page
sorry.
is missing. Last.
Is it consisting of 3 pages or more?
4 pages.
Four pages, last page signature हो जाना है.
अच्छी
इधर अच्छी 4 पेज.
कितनी कोच ना अच्छी बड़ी से देखियो.
अच्छा I'm sorry.
Silicon.
मैंने हारा था.
हाँ.
SD page. तब करिए कोई तो बता नहीं.
Give the last page को जेरोस करी दे दो.
I
इधर लगे दो इसमें देखिए आप. All right. The Land Council for the state has produced the compliance report dated 15/1/2024 of the IAC Sadar Police Station, Niagara. So also the supervision note of the Superintendent of Police, Niagara, dated 22/12/2023, in which various steps taken in connection with the investigation of the case for rescue of the victim girls, also for the arrest of the accused have been enumerated. Land Council for the state has already handed over the copy of such a report to the Land Council for the petitioner and take some further time to ascertain the development put of this matter in the week commencing. These are all taken on record. Put of this matter in the week commencing from 26th February 2024.
Item 9.
And also rescued. Please hand over. Are you aware that victim girl has been rescued?
The parents of the victim girl was rescued, but is handed over to the accused persons.
Yes,
Is 14 years, not yet 15 years completed, and alleged she's married and is sent to her.
Came to know law of the abuse court being accused to leave the house.
Parents,
The girl was produced before the court of SDGM Banki, where her statement has been recorded under section so and so. Handed over to the parents for a lekhaiji. Kaun kouchandi?
not there is wrong university.
Huh?
Girl has not been handed over to his parents university.
File an affidavit
Yes, just now I'm telling.
and will
Yes,
serious consequence will be
yes,
there.
yes, university.
All right. That instruction you have got till today.
Yes, yes, till today.
You have talked to the parents that he has not been handed over. She has not been.
She handed over to his matrimonial house.
We do not know. It is mentioned that parents को handover କରାଗଲା ବୋଲି 8/1/2024 ରେ order sheet ରେ ଲେଖା ହେଇଥିବ ଏବଂ she is staying with her parents happily.
Not yet.
All right. To the Land Council. Even though there was an order on 11/12/2023 for the personal appearance of the inspector in charge of Banki police station, the officer is not present. However, the Land Council for the state has produced the written instruction received from IIC Banki police station dated 13/1/2024. And a copy of the same has been handed over to the Land Council for the petitioner. In the status report, it is mentioned that the victim has already been rescued, whereafter and since he denied for or medical examination, the statement of the victim was recorded by the investigating officer, so also by the London SDGM Banki under section 164 CRPC. And the rescued minor girl was handed over to her parents on 8/1/2024. And since that day, she has been staying with her parents happily. The London Council for the petitioner submitted that a IAC has stated falsehood in mentioning that the rescued minor girl has been handed over to her parents on 8/1/2024. Let the petitioner file an affidavit to that effect during course of this week, and copy of the same be handed over to the London Council for the state. Put up this matter on 24th January 2024. Free copy of the order be handed over to the London Council for the state.
Item 10.
In the meantime, the 164 CRPC statement of the victim, so also the order sheet in which the victim has been handed over to her parents be obtained from the consent court staff. Register Judicial Cell sent a email
କାମ କରୁଥିଲା ତାପରେ ସେ ଘରକୁ ଆସି ଘରେ ରହୁଥିଲା ତାପରେ ସାର୍ ଅକରେନ୍ସ ହେଇଛି
And that girl,
ସେ ପଢୁଥିଲା ସାର୍ ଯାଜପୁର ଟାଉନରେ ସାର୍ +3 ଫାର୍ଷ୍ଟ ଇୟର ପଢୁଥିଲା
ଏକା ଗାଁର
ସାର୍
ବାପା କଣ କରୁଛି ସେ ପୁଅର?
ଚାଷ କରନ୍ତି
You have received a copy of it?
Just now, Lordship. What happened? The FIR was registered in 2010-2023, Lordship. Till file remains silent and taking any effective action to rescue the victim girl, where the victim
Now,
is staying in Odisha, Lordship.
now you have seen what steps they have
Yes.
taken.
Lordship,
So-
that is not clearly mentioned what dates. Date is not been mentioned. After filing, after honorable court direction, the IO has arrested the father of the main accused, Lordship.
Yeah.
After direction of part with the honorable High Court.
Yes.
Till date, not taken any action to rescue the arrest of the parents who is directly involved in for saying the victim to the son of the present father of the main
So
accused.
somebody has been arrested. If the arrest is
Yes,
necessary,
day before yesterday, also arrested. Also.
all right.
Yes, Lordship. But the FIR was registered to October 2023, Lordship.
Right. Heard the learned counsel for the petitioner, learned counsel for the state.
And specifically,
There was a direction to remain present somewhere. In pursuance of the order dated 2/1/2024. Anle ki check. Mr. Praveen Kumar Giri, SI of Police, Tirdi Police Station. You are the investigating officer?
Yes, sir.
Who is the investigating officer is present. And he has submitted the status report dated 16/1/2024, in which various steps taken for the rescue of the victim girl and for arrest of the accused persons have been mentioned. It is stated that the father of the main accused, who is also an accused in this case, namely Mano Govinda Naik, has been arrested and is now in judicial custody. Some further time has been sought for the rescue of the victim girl and arrest of the accused. Copy of the status report has been furnished to the learned counsel for the state. Put of this matter in the week commencing from 26th February 2024. Learned counsel for the state shall obtain up-to-date instruction in the matter. Personal appearance of the investigating officer is dispensed with. Sorry. Yes, next. No, not possible. Give them some time. They are doing that. Yes, next. Yes, next. Item 12.
Item 12.
My copy is also not in south.
This WPCRL.
Yeah. Receipt showing copy with after we order it, Lord.
Right. State submitted. He has not received the copy. Let the learned give serve a copy, so and so. None appears for the petitioner when the matter was taken up on 2/1/2024, and a submission was made by the Land Council for the state that he has not received the copy of the WPCRL. Land Council for the petitioner was directed to serve a copy with the interim application, and the Land Council for the state stopped. The same has not been done. However, one last chance is given to the Land Council for the petitioner to comply the order dated 2/1/2024. Put up this matter in the week commencing from 29th January 2024. In the meantime, if the copy of the WPCRL is served on the Land Council for the state, Instruction shall be obtained in the matter particularly about the rescue of the minor daughter of the informant from the opposite party through the opposite party number 3, that is inspector in charge of Baliapanda police station. Free copy of the order be handed over to the land council for this day. इस तरीके से कॉपी Yes, what development has been made? Mr. Das?
My lord, not yet been rescued, my lord. I'm taking steps.
Giving a copy to you?
My lord.
Of. Mobile switch off. Have you got any instruction where at which place in Tamil Nadu they are staying? Sir, you have sought for permission from the SP Bhadrak to visit Tamil Nadu. Sir. Are you aware that at which place they are?
Sir, mobile gote
No, it's all right. Don't disclose. If you have got the otherwise Tamil Nadu is not a small place that you will go and just catch them. So if you have concrete information that this particular location in the state of Tamil Nadu, they are there, then we'll ask the Land and Council for the state to do the needful, and so that SP Bhadrak will give you necessary permission. Because the permission is, if it is getting delayed, that then the person may move to another place. So you have now concrete information that they are staying at Tamil Nadu. Then why are you not granting permission?
I will take instruction.
All right. So and so is present. See. Hey. As for there was a direction to remain present. Huh? Who ordered it?
The last.
IIC so and so shall remain present. Okay. কি আসছেন দিয়ে? Your name is Swadhin Kumar Sahu. Swadhin Kumar Sahu, ASI of police. Who থানার?
Sir, Bhadrak Rural Thanas.
আচ্ছা ভদ্রক রুরাল সেগুলা কি লেখিব?
Sir,
ASI of police লেখা হয়নি, থানা লেখা হয়নি, এমতি লেখি ଦେଇଦେଲେ। Bhadrak Rural Police Station is present. The Land Council for the state has produced the status report in connection with Bhadrak Rural PS case number 621 of 2023 under section 363 of the Indian Penal Code of the IIC Bhadrak Rural Police Station, in which various steps taken for the rescue of the victim girl and arrest of the accused has been enumerated. The Land Council for the state submitted that as mentioned in the report, he will talk to SP Bhadrak for granting necessary permission to the investigating officer to visit the place where where information has been received that the victim and the accused are staying together. Put up this matter in the week commencing from 26th February 2024. Jagana Lekivani Code on Chandala. So, Land Council for the state shall obtain the status report, produce the status report of the case, personal appearance of the IAC, IO is dispensed with. A copy has been served on the Land Council for the petition.
Item 14.
Behalf of the state.
At the
Yes,
time of judgment, lordship, the appellants are 62 years. Where about the 2005?
No, they were released on bail.
Yes.
Right, on 2010 they have been released on bail. And the judgment shows that one was 60, the other was 62. So 2010 they were 772. 2010. So whether
Already sought for instruction, let it be day after tomorrow.
like serious.
ఇప్పుడు డేజ్ డేజ్
अच्छा Bichina date. Not be certain. 30 ବର୍ଷ ହେଲା stayed somewhere outside the Orissa since 30 years. The key report ଆସିଛି IIC ଦେଇଛନ୍ତି. He was released on bail by this court as per the in 2010. 30 ବର୍ଷ ହେଲା କଣ କେମିତି ତାର whereabouts ଜଣା ନାହିଁ. Arrest ହେଇଥିଲା, trial face କଲା, like for conviction ହେଲା, ଏଠି court ରେ jail criminal appeal ହଉଛି
At the time of
2005.
investigation, he has absconded. At the time of investigation, absconded.
No, this report is dated
Lordship.
23 ର 23 ର report ରେ ଲେଖା ହେଇଛି Mayadhar Naik stayed somewhere outside the Odisha since 30 years. The villagers could not say his whereabouts. So bail ହେଲା ପରେ ସେ କୁଆଡେ ଯାଇଥିବ ହେଲେ ବି 13 ବର୍ଷ ହେଲା 30 ବର୍ଷ କଣ ଲେଖିଛି. By the way, since one is dead, the other you also try to ascertain the correct information by day after tomorrow. We'll just proceed hear the appeal against this only Mayadhar, appellant number 2 only. Peruse the report dated 21/8/2023 of the inspector in charge of Tangi police station, from which it appears that appellant number 1, Bichi Naik, is dead. To that effect, the letter of the Sarpanch of Pori Roda Gram Panchayat dated 18/8/2023 has been annexed. So far as appellant number 2, Mayadhar Naik is concerned, it is mentioned that she stayed somewhere outside the Odisha since 30 years and the villagers could not say his whereabouts. The Land and Council for the state submits that the matter may be taken up next week.
Let it be next week.
Next week to ascertain further details about further whereabouts of the appellant number 2. Put up this matter in the week commencing from 22nd January 2023. In view of the report furnished by the IIC Tangi Police Station, this appeal so far as appellant number 1 Bichi Naik is concerned stands abated. Put up this matter so and so for ascertaining the whereabouts. Okay. Free copy of the order be handed over to the Land and Council for the अन्ना केस नंबर होची 2003 तो 2003 में भी गणा तापर अरेस्ट होचंदी ट्रायल फेस करचंदी कन्विक्शन हेची ताकू 23/11/2004
ସିଏ ଭାଇ ଗାଁ ରୁ ପଳେଇଥିବ ତାପରେ ଅକ୍ରାନ୍ସ ହେଇଥିବ କଣ କରିଥିବ ରହୁନଥିବ କାଳେ
ନାଇଁ ସେଇଥିପାଇଁ ଦେଖୁଥିଲୁ ଏଫଆଇଆର ଡେଟ୍ ଟା କେତେ ଏଫଆଇଆର ହଉଛି ତମେ ଘଟଣା ହଉଛି 2003 ର ଘଟଣା 2003 ପରେ ତାପରେ ଆରେଷ୍ଟ ହେଇକିନି ଟ୍ରାଏଲ ଫେସ୍ କଲା କନଭିକ୍ସନ ହେଲା 23/11/2004 ରେ ଏଇ ଯୋଉ ଜେଲ କ୍ରିମିନାଲ ଅପିଲ ହଉଛି 2005 ଦେ ୱାର ରିଲିଜଡ ଅନ୍ ବେଲ୍ ଇନ୍ 2010 ନା ତ 30 ବର୍ଷ ହେଲା କେମିତି ଆବସ୍କଣ୍ଡିଂ ରହିଲେ सरपंच गुड़ा कौन लिखी दी थी ताकू ये इंग्लिश ट्रांसलेट करी दे दी ये
Item 15.
The sole appellant, convicted under section 302 for life.
How many accused are there, Mr. Mulligan?
Sole
accused. Case trial under section 302.
Yes, ma'am. Basis of conviction in Quran and declaration. There is no.
Okay, please come to the FIR.
24th page. Relevant 26.
Just a minute.
May I read, ma'am?
Just Yes.
माननीय भारत अधिकारी पर्जंग थाना महाशय मु संतोष कुमार साहू बयस 25 वर्ष
Is PW?
1.
पर्जंग जिला ढेंकानाल मु आपण पाखरे आज 2/9/2001 तारीख दिन 4टा बेले पहुंची यही लिखित रिपोर्ट करेकी जे मु आज घरे थिबा बेले प्राय 11टा हेबो आंभ ग्राम गुंडीचा नायक पिता मिछु नायक आसी कहिला तुम भाई नरेश को बड़ बड़ ठारे आम ग्राम
Just a minute. Am grammar Gundicha Naik is PW?
Not exam.
Not exam. तुम भाई नरेश is the deceased.
डिसीज मैन बड़ बड़ ठारे आम ग्राम निवारण राउत
Basically appellant.
आपेलान पिता सहदेव राउत हाणी देछि से बड़ बड़ अचेत होई पड़िछि तुमे जा आनिबो ता सुनी मु सांदा मो बड़ भाई रमेश पाखु जाई घटना कहिली मो भाई रमेश
PW?
रमेश इज माय
Ramesh not exam.
Not
yes
exam.
नहीं रमेश इज ना
No, yes, my
रमेश
PW6.
06 माय
PW6.
06
Ramesh.
मोर भाई रमेश सानदारू कार जोड़ करी पर स्थल घटनास्थल को जाई भाई नरेश को कार चिकित्सा पई बरजंग डाक्तरखाना आनिले मु कार पछरे गोटे मोटरसाइकेल आसी बरजंग ठारे सुनिली कार टी मंडबल डाक्तरखाना को जाउछि मु पछे पछे गली मंडबल डाक्तरखाना ठारे पहुंची देखिली मो भाई नरेश मरी जाइछि सेटार मो खुड़ी पार्वती साहू प्रदूष हो जे ए जो ना जे PW4 माइला मते कहिला नरेश को आमे कार रे आनिला बेले बाटे नरेश कहिला बड़पाड़ ठारे से बांगुरी सिंगार बहीपारी बेपारी सुरेश बाज एग्जाम PW10 माइल पोटल ओजन करी देउथिला बेले दिन 11टा हेबो हटा दिन 10टा हेबो हटा निबारण राउत गोटे टांगिया रे तार डाहाणा हाथ बाहु को हानि देला निबारण राउतर टांगिया हाथ रे मोर भाई डाहाणा हाथ बाहु कटी अल्प लागि भीषण भाव रक्तस्राव हेबा जोगु भाई मरीगला तेणु मंडबल डाक्तरखाना आसी आपण पाखे लिखित रिपोर्ट करेकी जे मोर भाई को आम ग्राम निवारण राउत पूर्व गंडोल राग रखी आनी आउ हाणी मारी देछि तदंत करा
ये जो ये कौन गोटे परिवा बेपारी ना कौन
चासी
चासी चासी बिकुथिला बेपारी को बेपारी होची PW10
10
सेही समय रे घटनाटा हला से PW10 आई विटनेस नु
यस आई विटनेस
खाली डाइंग डिक्लेरेशन
टर्न होस्टाइल
so now there is no eyewitness.
No.
Mane eyewitness turned hostile. Okay. PW10 is the sole eyewitness. Turned hostile. Then the case rests upon the dying declaration. Oral dying declaration before whom?
PW2 6 8 9.
2 then 6
8 9.
8 9. आउ कौन अच्छी ता छड़ा डाइंग डिक्लेरेशन छड़ा
PW5 is doctor.
डॉक्टर PW5 then this dying declaration has been made on the way to the hospital.
Yes,
or at different places.
Different places. At the spot.
At the spot.
And
अच्छा एमाने सबु विभिन्न पॉइंट रो डाइंग डिक्लेरेशन नो साकी अच्छा PW2 को पॉइंट रो
स्पॉट में
PW2 स्पॉट आउ स्पॉट रो की अछंदु
स्पॉट में PW 6
PW6 कोडी यार
PW6 इज ब्रदर में
नहीं को जगह वेहिकल नेला बले ना स्पॉट
नेला बले
PW6 ला vehicle. Then PW8
में
ठीक से देखिए कौन ताले स्पॉट वाला को आगे सारीवा तापर vehicle वाला को धरियो
स्पॉट रहेगा सिस्टर स्पॉट
अच्छा पीता माने PW2 और PW8 हो जंती स्पॉट रो व्हाट अबाउट PW9
car on the way.
Okay, so PW6 and PW9 are the vehicle dying declaration. Okay, so let us start with PW2. Page number
39.
I know the accused, President Dog, who is my co-villager. This is Naresh Chandra Raut, was my co-villager. About 1 and 7 months back, Naresh died. On 7/9/2001, at about 8 a.m., I had been to my land to plug potoro. After selling potoro, I came to River Brahmani with grass to take my bath. While I was about to take my bath, I heard one alarming sound. Naresh Saj Bopalo Malo Marigali, and he was asking for water. Hearing this, I rushed to the spot and saw Naresh lying on the ground, and his right hand has been severed from the body. Seeing me, Naresh told me, "Give him water." On being asked, Naresh told me that accused Nibarana gave him a hatchet blow on his person, and saying so, he told me to give information in this house. I nourished him by giving water after pressing my napkin, which I watered from the river Brahmani. Thereafter, Naresh told me that the hatchet whereby accused Nibarana had given blow on his person while lying there. That hatchet was stained with blood. I also kept that which is hidden inside my potolavari, and thereafter, while I was returning on the way, I saw Parvati Sahu and Gitanjali. On being asked by the Parvati Sahu, I
Who are
told
they?
that, my lord,
Parvati Sahu and Gitanjali?
Parvati is PW4, my lord, and Gitanjali is PW, sister PW 8, my lord. PW 8.
4 and 8.
4 is not a witness to the dying declaration.
She
Yes,
was. What do they turn her?
Don't
Understand.
PW4 witness to DD. Okay. Yes, continue.
On the date of ignition, I also brought out the hatches which I had kept hidden inside my potolavari and produced the same before the police. Police searched and the same on my production by preparing seizure list. Exhibit 2 is the said seizure list. Exhibit 2 1 by 1 is my signature. After 5 days of occurrence, I was examined by police. MO1 is the tangi having broken handle, which was found lying at the spot. MO1 was seized by the police on my production on the date of my examination. Police brought me to my field where I had kept the hidden MO1, and I brought out the MO1 and produced the same before the police. After occurrence, I had gone to my father-in-law's house with some sweets, as the wife of my brother-in-law was at the advanced delivery stage.
No, what is the rest page? 40, 41, 42?
40, yes, 40. Is the 40, is the page 40, my lord.
Oh, this is 40, but thereafter
41. 41 cross annexation.
ସେଟା କାଢିକିନି ତା ଭିତରୁ ଷ୍ଟାପଲିଂ କର ସେଠି ସେଠୁ ବାହାର କର। ସେ ଯୋଉ ଦଉଡିରେ ବନ୍ଧା ହଉଛି ତ, ହଁ ସେ ସୂତା ଖୋଲି ଦିଅ, ଖୋଲିଦେଇ ତା ଦେହରୁ ସେ ଜାଗାରୁ କାଢି ଯୋଉ ଜାଗା ରହିବା କଥା ରଖ। ये जो दी जन को पाखरे सी आसिकिनी कहिला
PW
जन
4
नाम
and
छी पार्वती साहू और जन
yes, 8
गीतांजलि
Peter 8
पार्वती साहू तो आपण कहले नॉट
Hostile.
सपोर्टेड
Yes.
8 भी कहूनी आगे मते कहला
सपोर्ट तो कलानी असुविधा गीतांजलि कहूची जे मते
कितने कहूनी मते कहछि बोली PW 2 कहछि बोली कहनी तोरा 5 डे occurrence पर एग्जाम नहीं थे
जस्ट
सिर्फ PW 2
PW 8
इवन साइलेंट रहले 5 दिन पर साइलेंट रहला
no no PW2
नसिम पारा 5 में
just a minute
5 examination chief
PW2 is the witness to the dying declaration.
Yes.
He was examined by the IO
after 5 days.
after 5 days. Right?
Yes,
That was explained.
Well, I will see that. Then second point, he disclosed before PW4 and
Eight.
PW8. Right?
Yes.
PW4 not supported.
Yes.
Hostile.
Hostile. Then PW8 not stated that PW2 made any disclosure
Yes,
before him.
Yes.
She said only one Gundicha. She came to know about that incident from one Gundicha.
Would not examined.
Gundicha but PW2 ର version को corroborate କରିବା ପାଇଁ
Yes.
PW8 not stated to have heard from PW2. Okay, so ଆଉ ଗୋଟେ କଥା କହୁଛି ସିଏ ଯେ after the occurrence I had gone to my father-in-law's house with some sweets as the wife of my brother-in-law. ମାନେ
ଭାଉଜ
ହଁ ମାନେ ଶଳା ହବ ବୋଧେ
ଶଳା ଭାଉଜ
ଶଳା ଭାଉଜ he was in advanced stage of ସେଥିପାଇଁ ଯାଇଥିଲି ମିଠା ନେଇକିନି ତାପରେ that was the reason why you say that.
Yes. Yes.
Okay, about the delay in law.
That was also explained in cross examination.
Delay in
he even did not made an attempt to shift the receipt, my lord. Did not made an attempt to shift the receipt, my lord. This
save the receipt.
Did not made an attempt shift the receipt to medical.
Read the cross examination.
Yes, my statement was recorded by the police at about 4 p.m. When I was examined by the police. After I was examined, I was taken by the police to my
okay. What is the date of if he is examination? Because this occurrence took place as it appears from the FIR. Date of occurrence is 7/9/2001. So when PW2 was examined by police, IO has stated anything or any questions has been put. Who is the IO?
PW11.
11. Just a minute. दुई नंबर साखी को केबे एग्जामिन कला विषय किछि कहूची तो आपण केम जानले 5 दिन परे से डिस्क्लोज करछि
एग्जामिनेशन चीफ रे कहजन PW पारा 5 रे कहछि पारा 5 माइल एग्जामिनेशन चीफ यस मैम
आफ्टर 5 days of the अच्छा ठीक है ओके तो PW examine after 5 days. Explanation given. नहीं एक्सप्लानेशन जो कहितला जे घटना परे मु जाईची मो ससुर घर जाईथिली शळा भाउज एडवांस स्टेज रे थिला तनु मिठा नै की जाईथिली as he stated that he stayed there for 5 days. मिठा दे पळे आस्थिबो तो अवेलेबल अछि तो
रहिछु
किम की कहला
ये पचारना कोई
पचारना कोन आपण एक्सप्लेन करियो ना सी काई पचारिबे आपणको साखी 5 दिन पर बयान दउची मु डाइंग डिक्लेरेशन
यस पारा 8 मिलो पारा 8
मतलब you please read it out.
Right.
This time, that is after the occurrence, I remained for the longest period in my father-in-law's house.
No, please continue with that. କୋଉଠି
Please.
ଛାଡ଼ିଥିଲେ ଆପଣ?
My
Sorry,
statement,
ଛଅ ଛଅ
my
paragraph.
statement was recorded by police at about 4 p.m.
Hmm.
when I was examined by the police. After I was examined, I was taken by the police to my Potravari at Bodapada, where from I brought out the MO1 and produced the same before the police. And police record my statement there again. At about 3:30 p.m. on the date of occurrence, I went to my father-in-law's house. Till 3:30 p.m., I had not revealed about the occurrence to anybody else. Occurrence took place 10 a.m. Kothali Moda is the village of my father-in-law. I remained in my father-in-law house for about 5 days, but I did not reveal the occurrence to anybody else. I came to my village after 5 days on my stay in my father-in-law house. I reached in my village at 1 p.m. on the date on which I was examined by police. I had no other work in my father-in-law house except giving sweet, as the wife of my brother-in-law was in advanced stage of delivery. This time, that is after the occurrence, I remained for the longest period in my father-in-law's house. It is not a fact that I have not stated before the police regarding my absence from my village after the occurrence till my examination by the police in connection with this
It
case.
is not a fact that I have not stated before police regarding my absence.
I alone
Hmm.
was taking my bath when I heard the shouts of Naresh. The distance between the place I was taking my bath and the place where the deceased Naresh was shouting would be equivalent to the distance between the court premises of Kamakhanagar and the police station at Kamakhanagar. While I came to Naresh, I did not find anybody on my way
ସେଇଟା ଆମେ
to
କେମିତି ଜାଣିବୁ? ତମ କାମାକ୍ଷାନଗର କୋର୍ଟ ପ୍ରିମାଇସେସରୁ ପୋଲିସ ଷ୍ଟେସନ କେତେ ବାଟ?
While I came to Naresh, I did not find anybody on my way to Naresh. While I reached near Naresh, he was in sense.
ଇଏ ଗାଧଉଥିଲା, ଗାଧେଇଲା ଜାଗାରେ ପାଟି ଶୁଣିଲା. So suppose the distance would be now 2 kilometers.
No, no.
ଆରେ
ଏଟା ମୁଁ ଦେଖିଛି.
କଣ ଦେଖିଛନ୍ତି? ଆପଣ ସାକ୍ଷୀ ଦେଲେନି ନା ଦେଖିଛନ୍ତି?
କୋର୍ଟରୁ ପୋଲିସ ଷ୍ଟେସନ ଟା କେତେ ବାଟ?
କେତେ ବାଟ?
ଜଷ୍ଟ ଏଇଠୁ ବାର ଯାକେ.
ଏଇଠୁ
ବାର ଯାକେ.
After giving water to Naresh, I came to my village. Naresh told me to intimate about the occurrence to his family member. On the way, I saw Parvati and Gitanjali. Parvati and Gitanjali were aware about the occurrence before my information.
ये किए पार्वती गीतांजलि
Parvati PW4 and PW8 माइल.
ना ये लोग को माने आकर
गोटे ला डिसीज रा आंटी गोटे ला डिसीज रा भौणी गीतांजलि.
गीतांजलि
ये हला
पार्वती ला खुड़ी.
Wait. PW4 is the aunt of the deceased. PW8 होची
sister.
His sister.
Parvati and Gitanjali were aware about the occurrence before my information to them. Accordingly, they were coming in search of Naresh. On being asked by Parvati as to description of the spot where Naresh was lying, I described the spot. It is not a fact that I was never taking my bath in the river. I had never heard Naresh shouting. I had never gone to the Naresh, nourished him with water, and also I never heard anything from the Naresh. It is not a fact that Naresh pointed out MO1 and I had hidden it in my Potalvari and subsequently produced the same before the police while I gave my statement. Thinking that somebody would take away MO1, I kept the same hidden in my Potalvari. I did not reveal anybody in my village that I had hidden the MO1 in my Potalvari. It is not a fact that all along I was in my village from the date of occurrence till my examination of police. It is not a fact that during the said period, I had never gone to the father-in-law's house as stated earlier. Even did not tell regarding concealment of MO1 by me in my Potalvari to the aunt and sister of Naresh, whom I met on the way to the village on the date of occurrence. I am elder father of Naresh in village Korsi. It is not a fact that I have never hidden MO1 in my Potolabari and there was no such recovery and production of MO1 before the police had. Till 3 mile, he was in village. Till 3 p.m. he was in village, my lord.
This FIR was lost when?
It was lost, madam.
Information received 4টা দিন ଅପରାହ୍ନ 4টাରେ କୋଉଠି କହିଲେ 6ଟା ବେଳେ ଯାଇ ସେ ଥିଲା ବୋଲି ଆଇଓ କଣ କହିଲା PW11 କଣ କହିଲା ଘଟଣା 4ଟା ବେଳେ ସେ ଆସିଲା ରିପୋର୍ଟ ଆସିଲା then he registered the case. Time of registration of the case କେତେବେଳେ
7:09
p.m. Then what the IO has stated
on 7/9/2001, I was the OIC of Parjanga police station. On that day, at about 4 p.m., one Santosh Kumar Sahu appeared before me and presented a written report to the effect that his brother Naresh Chandra Sahu had been murdered by one Nibaran Raut by means of Tangia. He further stated that he had shifted the deceased hospital. As the information received by me revealed a cognizance offense under section 302 IPC, I registered Parjanga PS case number 87/2001 by making necessary endorsement on the affair and drawing a formal affair. Exhibit 1/2 is my endorsement, 1/3 is formal affair. Thereafter, I took investigation of the case. I examined the informant and proceeded to the Talcher hospital. At Talcher hospital, I held inquest over the dead body of deceased Naresh Kumar Sahu and prepared the inquest report. Mark Exhibit 5, already marked, and Exhibit 5/2 in my signature thereon. On the next day, that is on 8/9/2001, I proceeded to the spot.
ସନ୍ତୋଷ କୁମାର ସାହୁ ହଉଛି
PW1, my lord.
PW1 ଯେ ସେ ହଉଛି
Brother of the
ଭାଇ ଆଚ୍ଛା ଏମାନେ ଯୋଉ ଭଉଣୀଟା ଯିଏ ସପୋର୍ଟ କଲା 8 ସିଏ ହଉଛି ଗୋଟେ ଭଉଣୀ ଆଉ ଇଏ ହଉଛି ଭାଇ ଇଏ କଣ କଲା 8 ନମ୍ବର ସାକ୍ଷୀକୁ ଟିକେ ଆସିଲେ
Deceased Naresh was my brother. On 7/9/2001, while I was in house, one Gundicha came to our house and told me that Nibai had dealt
Gundicha not exam.
Nibai had dealt court blow on my brother Naresh. I then went to my aunt and told her. So myself and my aunt rushed to Bodpal and found that my brother was lying senseless below a mango tree, and his right hand was caught above the elbow. It was almost amputated. Subsequently, on being asked, my brother told me that this is Nibaran dealt a Tangia blow, accused injury
and caused injury.
Yes, caused injury. We shifted to him for Jung Hospital. Then we took our brother at Mondapala Hospital, but he died there. Cross-examination. Myself and my aunt, PW4, went to see my brother. Musadhala was present then. He went to see my brother. My brother was senseless. We sprinkled water to get his sense. 10 to 15 minutes after my arrival, my brother got sense. He was talking in low voice. PW4 and Musa were present when my brother told that accused dealt him a Tangia blow. It is not a fact that my brother had not told me anything that I deposed falsehood. It is not a fact that my brother had not gained his sense. Musadhala was not examined, my lord. Musadhala also not examined.
No, this what is the PM report?
PM report, my lord. PW5 doctor, my lord. 8/9/2000, I was working as assistant surgeon, ST Hospital, Talcher. On that day, police requisition, I conducted postmortem examination over the dead body of deceased Naresh Chandra Sahu. son of Muraldhara Sahu of Chandpur, PS Parjang, District Dhenkanal, being identified by the Constable Bhajamana Raut, C411, and Ramesh Chandra Sahu. On my examination, I found follows. There was a cadaveric spasm of right hand with clenched fist and deep lacerated wound of the right arm near elbow joint. The lower end of the humerus was cut completely. The biceps muscles and other muscles of arm was deeply lacerated. There was a dislocation of right elbow joint. All other organs were intact. The brachial artery of right side was cut completely. The left chamber of the heart was empty. 3. The injury of antemortem nature could have been caused by sharp cutting weapon. The cause of death was due to excessive blood bleeding from the injured brachial artery and deep cutting of the right humerus bone, which led to shock. The time since death is 24 hours from the time of my examination. Nature of death was homicide. The injury was fatal in ordinary course of nature, possible to cause death. Exhibit 3 in postmortem report, Exhibit 3-1 3/1 is my signature. On 4/10/2001, the OIC Parjang PS sent a axe and made a query as to whether the injuries caused could be possible by the said axe. I have given the description of the weapon in my report. I opined that injury inflicted on the right arm of the deceased is possible by this tangia. I have affixed my label with signature on the axe, that is MO1, Exit 4 is query, Exit 4/1 is my opinion with signature. Cross-examination of defense. Weapon offense was sent to me was in a packet. I opened the packet, examined the MO. After affixing my label with the signature, returned the same along with the MO to the police. There was no blood stain on MO1. Immediately, if patient would have been treated, there was a chance of his survival.
So, Mr. Mulia, let us say that so far as this PW2 is concerned,
Yes, ma'am.
there is some delay in disclosure
Yes,
of this aspect.
Yes.
But what about the other witnesses?
Other witnesses, my
There are as many as
PW6, ma'am.
four witnesses to the dying declaration, as you have
Yes.
said,
That's
out of which PW2 and PW8 tell about the dying declaration made at the spot.
yes,
Then PW6 and PW9,
Yes.
they state about the dying declaration made in the PW6 and PW9
PW9, ma'am.
टा पूरा पहले
Nine.
डॉक्टर पोस्टमार्टम
No,
एग्जामिनेशन
no. Five, my lord. 5 is doctor.
PW5 is the doctor. Just a minute. PW5 is the doctor. Right. PW9, what he has stated.
PW9 is a friend of brother of PW6, my lord, brother of the deceased. PW6 is the brother of the deceased, my lord. PW6, my lord, said a different thing in different stages, my lord. PW6, my lord, is a brother of the deceased and said a different things in different stages, my lord.
No. Main crux of the matter that who has dealt, and that part remains consistent in the evidence of all these four witnesses. Two are at the spot and two while being shifted to the hospital. They have stated that it is the appellant who dealt a tangia blow. So if your submission is accepted that PW2 was examined or gave his statement after 5 days, so there is every chance that he might have concocted such a version. So let us, for the time being, for the sake of argument, keep it aside. The evidence of PW2. What about the other three witnesses to the dying declaration?
That's him, can see P6 man. He's the brother of the district man. That's why I'm calling to place man. P6.
PW6.
Yes, madam.
Yes.
The occurrence took place on 7/9/2001. On that day, I was in my tailoring shop at Sanda. My younger brother Santosh rushed towards me by a bicycle at about 11 a.m. and informed me that accused Nibarana had assaulted Naresh by means of one axe. Thus, immediately, I arranged a car and went to our village and keeping the car at outskirts of the village. And we walked up to the spot covering 1 kilometer. The spot is at Baunsapara, where my brother Naresh was lying near bamboo bush having bleeding injury on right arm just at the elbow joint. Parvati Sahu, Gitanjali Sahu, my sister, were also there before my arrival. By the time I reached, my brother Naresh was alive and able to talk. On being asked, Naresh told me that accused Nibarana Raut assaulted me by means of axe and ran away. At that time, when Naresh was weighing Potolo and giving the same to the businessman, accused Nibarana gave him Tangia blow and ran away. After we brought Naresh by means of Khatia to jeep, I had taken and kept at the outskirts of the village. Parvati Sahu, Basanta Das, Gitanjali, and some other have heard the deceased saying to have been assaulted by the accused Nibaran. Thereafter, we took our brother to Forjang Hospital. They referred the matter to Talcher
So
Hospital.
this witness is not a, you said in the earlier that PW6 is a witness to the dying declaration made during
Transit.
transit, but
Yes.
he is a witness
sir.
to the
Spot.
spot, right?
Yes,
Yes.
So who is then transit रे किए कହୁଛି?
PW9.
9 man.
अच्छा PW9 ହେଲା vehicle.
Subran Saman. On 7/9/2001, Norris died. The deceased is the brother PW6 Ramesh. Ramesh is having a tailoring shop in our village. Around 10:30 a.m. on that day, I had been to tailoring shop of Ramesh PW6. By that time, his brother Santosh came and told that the accused Nibarana had dealt a cut blow to Naresh. His brother, on being called by Ramesh, I accompanied him and went to the place of occurrence in a car. We found below a mango tree Naresh was lying. He had sustained a cut injury on his right arm, which is almost amputated. We brought him to the car by cart. Therefrom, he was taken to Forjang Hospital. On being asked on the way, the deceased Naresh told that accused Nibarana did a blow by Tangia. Forjang doctor gave some aid therefrom, he was shifted to Mandapara Hospital. He died. Cross-examination defense. I knew Naresh was coming to solve. I do not know accused Nibarana. By the time we went there,
ଏ ଯୋଉ ପ୍ରଥମେ ଯୋଉ ମୁଣ୍ଡାପାଳ ହସ୍ପିଟାଲ କୁ ନେଇଥିଲେ ସେଠି କୌଣସି ଡକ୍ଟର ଏକ୍ସାମିନ ହେଇଛନ୍ତି?
ନା
ନାଇଁ।
ଡକ୍ଟର ଗୋଟେ ଖାଲି
ହଁ ମାନେ ଯିଏ ପିଏମ୍ ଡକ୍ଟର
Yes.
କାରଣ ସେ କହୁଛି ନା we took our brother to ମୁଣ୍ଡାପାଳ ହସ୍ପିଟାଲ but he died there. ତାପରେ ପୋଷ୍ଟମର୍ଟମ ହେଲା.
लेकिन Forjang doctor gave some aids.
ହୁଁ
Forjang doctor para 2 रे. The
हाँ,
blow
Forjang
time. Forjang doctor gave some aids. Therefrom, he was shifted to Mandapal Hospital where he died. I knew the Ramesh. He was coming to shop. I do not know accused Nibarana by time. We went there. Some female Ramesh was present there. By then, the aunt of the deceased, that is P4, Gitanjali, P8, and two to three others were there to whom I did not know. By the time we reached, the deceased had sense. At the spot, I did not ask the deceased anything. Myself, Ramesh, and the car driver were present when the deceased Naresh told me. I cannot name the driver of the car, but belongs to the Sanda. I cannot say if Ramesh and car driver had when the deceased told me. I did not tell about this occurrence to anybody.
You see,
Driver was
first
not
of all, the blow was given on the right,
right.
right? There was it was almost completely dislocated, almost dislocated. Tikke khali just bode lagi kini rahichi. So the statement has been given by the PM doctor, and you have not elicited anything from the doctor's evidence at least that a type of blow hela pare gote lokor survival chance न थाए तार state of mind उपरे किछि question पचार नाहंती कोनोसी प्रश्न पचार नाहंती
खाली
ताहले
खाली कहजनी cause of death was due to excessive bleeding from the injured.
ठीक अछि excessive bleeding हेले it's not that there would be death would be instantaneous, maybe after some time हला तेणु जिए चारिटा जो साक्षी आपणकर आसुचंती जदि सर्वाइवल चांस रही एवं तीनिटा साक्षी स्पॉट रे कहउचंती डाइंग डिक्लेरेशन कला आ गोटे ऑन दी वे टू दी हॉस्पिटल चारटा साक्षी गला ए जो स्टेटमेंट गुडा को रहुची एवं जो प्रकार दी साक्षी statement दउचंती that this is the manner of assault, that means assault was made by a sharp cutting weapon on this part of the body, that is getting corroboration from the medical evidence.
Yes.
So only thing you have brought from the evidence of that PW2 that for
Delay.
5 days he did not give his statement, except that even if that is discarded, then the other 3 witnesses, 2 are at the spot and 1 is at the vehicle. If their evidence is not discarded, then the dying declaration itself, if it is believable, then that would be sufficient to convict a person. If the court, if no other evidence is there, but the court accepts the dying declaration, that can form the basis of conviction also. If the evidence we find that these 3 witnesses evidence at least are trustworthy, we are leaving PW2 because some kind of let us say suspicion arises whether he was why he kept it there and why he did not stay there for such a 5 days, why he has not disclosed before any family members in the father-in-law's house, and the person before whom he stated to have disclosed 2 witnesses, 4 and 8. None of them have stated that this PW2 disclosed before them. So leave those, let us say, leave that PW2. But what about the others? That means this 4, 8, and no,
Four-
sorry,
four, eight,
6,
eight.
6, 8, and 9.
6, 8 are my brother and sister, the interested witness man. And
No, the person who will come to the place of occurrence, the others may not come to the place because they know that
no, well,
there
they
might be a
stated
police case. They may not come.
One Musa was present, who was not examined. Musa was present.
It's all right.
Yes, ma'am.
Whosoever present,
Yeah.
what you have elicited merely because somebody is related to the deceased, that cannot be a ground to reject his testimony. They are the person who, when get the news or message that deceased has been assaulted, obviously they would rush to the spot.
Yes.
And when they rushed to the spot, found the deceased in such a condition, and the deceased was able to talk. That is the some statement of these witnesses, and in that way he has made a disclosure. Then he was also shifted, and on the way he died.
PW8, my lord, the sister, is evidence not corroborated by my lord. Anybody, my lord. PW8, the evidence to corroborate करना है. So before,
No, PW8, he was at the spot pra कहउछंती.
spot run.
हाँ, spot रे तो आपनकर दुईटा को छाड़ देले भी 6 भी कहउची spot रे dying declaration हला बोली. ता माने
गीतांजलि पर गीतांजलि कहला बोली से कोई मुसा धड़ा और PW4 प्रेजेंट थे.
No, you see, it was not made only one point. गोटिए थरो से कहिनी. ये लोक विभिन्न समय पहुंची 2 नंबर साक्षी प्रथमे पहुंची, राइट. सेते बेलकु अन्य केही साक्षी नथिले जदि ता एविडेंस को तापरे जणे जणे पहुंची एवं 2 आउ 6 ए सॉरी 6 आउ 8 एमानक पाखरे स्पॉट रही एवं 6 एंड 8 एका संगे पहुंची बोली भी किछि नाही. तेणु आपण कहबेनी जे 6 कहूनी जे 8 पखरु में को कहिला बेली 8 कौनी 6 को कहिला बेली that's not the thing. If once the dying declaration would have been made, matter is different. But if the deceased is alive for some time, arrangements are made and he was shifted to the hospital, and till the period he stayed at the spot in such a condition, different persons came to him, and that is 2, then PW6 and PW8, and they asked and the deceased made the disclosure. So why these witnesses, at least 6 and 8,
Yes, ma'am.
you now confined to 6, 8
Yes, ma'am.
and
That's
9.
PW6 stated, my lord, at the spot. When Subhranshu was present, he heard when my brother narrated the occurrence. But PW9 not stated, my lord, that in the spot, he heard that the deceased made any statement to the PW6, my lord.
The multiplicity of witnesses is not the requirement. ये ता पाखरे थिला से dying declaration पाखरे कहिला बेले 5टा साक्षी थिले. It's not necessary for the prosecution to examine all the 5 witnesses.
Corroboration हो रही है.
No, no.
PW6 और 8 corroboration करना जो PW8 जहाँ करे.
134 Evidence Act, it says that quantity is immaterial. It is quality which is material. If we believe about the presence of PW6 at the spot, the disclosure made by the deceased before PW6 at the spot, that he was in a fit state of mind to give the statement and which is acceptable. And if you have not elicited anything, then that is sufficient, that can be accepted.
You know, a single blow and excessive bleeding, my lord. Not case of 302, my fault.
11. ସେ ତ କହି ରହେନି No, we are not, there is no, he has turned hostile. କାହିଁକି ନା ସିଏ ତାର police statement ଥିଲା ଏଟାକୁ prosecution cross examination ନେଇକରି had stated that from the our purchasing protocol so and so the accused Nibaran went there with a tangia dealt with so she support करानी ये case रो dying declare जो direct evidence PW10 रो evidence He said that somebody might be taking it away. That is the reason why I kept there. In the examination sheet, he has not stated so. The examination sheet, he has not stated. No, they asked it in the cross-examination that कौन ପାଇଁ ତମେ ଲୁଚେଇଲ था ଇଏଟାକୁ ସେ କହୁଛି କାଳେ ମୁଁ ଭାବିଲି ଯେ କିଏ କାଳେ ନେଇଯିବ ବୋଲି ସେ ଯୋଉ ୱେପନ ଟାକୁ ସେଇଥିପାଇଁ ମୁଁ ତାକୁ ପୋଟଳ ତିଆରି ଭିତରେ ଛୁପେଇକି ରଖେ he has stained with blood, but other witness also there is no blood. That's it. Hatchet ଏଠି not stained with blood. No, that is
Schedule 5.
Sample 3 number. Acts with broken handle, blood, human blood. Group re no opinion ଅଛି. But human blood was there. And that was also sent to the doctor and he has stated that now the acceptability of dying declaration is the crux of the matter. So if we believe dying declaration, then if at all he has assaulted, then what would be the offense? That is another thing. Because somebody is giving a blow on the right arm. So whether it would fall within 302 or it would be a 326 case, like that, that is to be seen. So paper just I will time perhaps about that would not be a ground to say that it achieved. That is in section 300. Whoever causes death by doing an act with the intention of causing death or with the intention of causing such bodily injury as is likely to cause death, or with knowledge that is likely by that act or commits offense of self-homicide. Right? Explanation to Pahela. When the death is caused by bodily injury, the person who causes such bodily injury shall be deemed to have caused it, although by resorting to proper remedies and skillful treatment, the death might have been prevented. Then a question ପଚରାଯାଏ ଆମେ ଯେମିତି ସମୟ ଅନୁଯାୟୀ ନେଇଥିଲେ ହୁଏତ ସେ ବଞ୍ଚି ଯାଇଥାନ୍ତା ସମୟ ଅନୁଯାୟୀ ସବୁଠି ଫ୍ୟାସିଲିଟି ଥିବା ଦରକାର ହେଲା ଭୁବନେଶ୍ୱରରେ କି କଟକର ହସ୍ପିଟାଲ ପାଖରେ ହେଲା ତାକୁ ନେଇ ଇମିଡିଏଟଲି ଟ୍ରିଟମେଣ୍ଟ କର କୋଉ ଗାଁ ଗହଳିରେ ଜଣେ ପଡ଼ିବ ଟ୍ରିଟମେଣ୍ଟ ହବ ତାକୁ ହସ୍ପିଟାଲ ସେଠି ନେଇକିନି ସେଠି ଫ୍ୟାସିଲିଟି ନାହିଁ ତେଣୁ ତାକୁ ଯଦି କହିଥାନ୍ତି ତମେ ତାକୁ so that's why explanation 2 is inserted for that purpose, keeping in mind that there may be question like this. So Mr. Mulia, how do you dislodge the statement of these three witnesses, 6, 8, and 9?
Yes.
PW6, if you come to page 52 and come to paragraph number 3, Parvati Sahu, Gitanjali Sahu,
My sister
were
also there.
were also there before my arrival. These two witnesses have been examined,
PW4 and
and
PW8.
PW Parvati is PW4 and Gitanjali is PW8. Okay. Then by the time I reached, my brother was alive. This is a very pertinent statement that the deceased was alive and able to talk. On being asked, Naresh told me that accused Nivaran Rao assaulted me by means of an axe and ran away. By that time, when Naresh was weighing pottery, giving the same to the businessman, accused Nivaran gave him Tangia blow and ran away. Thereafter, we brought Naresh by means of a jeep, by means of a khatia to the jeep I had taken and kept the outskirts of the village. So and so have heard the deceased. अच्छा सी कहला जे एई माने मध्य मु कहला बेले ए माने सुनिचंती
पार्वती साहू बसंत दास
अर्थात पार्वती हला PW4
बसंत दास नॉट एग्जामिन
not examine गीतांजलि
PW8
ए माने मध्य सुनिचंती
PW8
आधिरु PW8 होची ये PW4 होस्टाइल गला अच्छा
PW8 कोड कहन जे आस कहले
Thereafter, we took the brother to Parjang Hospital. They referred the matter to Talcher Hospital, where the doctor declared Naresh dead. It would be 4 to so and so. Please read the cross-examination. Let us see. This
Subhranshu Sahu had, when my brother reported about the, he not stated anything. That's the deceased tell anything to the PW6 mile at the spot mile. Except Subhranshu Sahu, no other person was present when my brother reported matter to me about the occurrence. Because spot रह गए Subhranshu Sahu थिला Subhranshu Sahu सामने रे गइला Subhranshu Sahu कोडी कोनी spot रह गए वो हालाल PW6 को After intimating my brother returned to village, I went to search of one car. Alok Pani was the owner of the car, which I took on hire. I cannot say the number of the vehicle. Samir Sahu was the driver of the said car. He was man of Sanda, Baliposi. The driver of the car did not accompany me to the spot. 10. At about 7 to 8% were there, where my brother narrated about the occurrence. She said, nobody is there. In para 10 says 7 to 8% is there. You contrary your own statement, madam. Santosh had not gone to the spot. Immediately after my arrival, I asked about the occurrence to Naresh, but no other person present there. Immediately after hearing about the assault on Naresh, I tried to take Naresh to hospital, and so I have not narrated the same to anybody else. At Mondopala, Talcher Hospital, police reached there. My brother reported about the matter. There was two police. My brother Santosh submitted written report to the police. Santosh Kumar Sahu wrote the affair. Parvati Sahu, myself, Subran Sahu had been to hospital by the car in which Naresh was taken. Subran Sahu has also heard the Rishi saying that Aku Nibaran had assaulted him on the way to hospital event. I cannot say if the driver of the car heard about the occurrence from deceased or not. While the deceased Naresh reached at the Mandapara, he was unable to talk. It is not a fact that Naresh has never told me that Aku Nibaran assaulted him by means of Tangia. On 7/9/2001, I have been examined by the police at Mandala Hospital at about 4 p.m. Santosh and Parvati Sahu were also examined by the police on the same day at Mandala Hospital. I have not stated Santosh that accused had assaulted Naresh. Para 17 mile. I had not stated Santosh.
Exclude PW2 if we do not accept the evidence, but still then there are three other places to be dying declaration. That is PW 6, 8 and 9. 6, 8 and 9. 6, 8 have stated about the at the spot and 9 about in that day. And all of them have stated that they were in sense and made the dying declaration. And Naresh was able to stop and early. And doctor has also corroborates two type of କହୁଛନ୍ତି ଯେ ମାରଲା ବୋଲି 9 ମଧ୍ୟ କହୁଛି ଯେ a certain pot injury and on being asked ସେ ତ କହିଲା ଯେ ମୋତେ ଟାଙ୍ଗିଆ ବହୁତ ଦେଲା. No, they have brought up in the proceedings that there was previous hostility between them. You Sakire, PW6 in paragraph 19 there was previous enmity between the accused Nibaran and deceased Naresh. The बाहर कोई ना आने the cross examination chief registration of the Have you brought any citation about that? First of all, about the dying declaration acceptability. Second one, suppose the blow is given on a single blow on the right arm, and due to this excessive this bleeding, the whether it would come within 302 because that 300 ର ଗୋଟେ definition ରହୁଛି ଯୋଉଟା murder ବୋଲି ସେଠି You see, come to 300 clause thirdly. 300 clause thirdly.
Done with the intention of causing bodily injury to any person, and the bodily injury intended to be inflicted insufficient ordinary course of nature.
So culpable homicide culpable homicide কোটি murder হবো সেটা এই চারিটা ক্লজ রে ডিফাইন ହେଇଛି বা এনুমেরেটেড ହେଇଛି এবং কোউଠି murder হবনি সেটা পাঁচটা এক্সেপশন রে ହେଇଛି when the culpable homicide is not murder ସେ ଯୋଉ culpable homicide ଯୋଉ murder ହବ ତାର ଯୋଉ thirdly ଟା ଅଛି if it is done with the intention of causing bodily injury to any person or bodily injury intended to be inflicted is sufficient in ordinary course of nature to cause death. Eti PM report ro jo doctor ro opinion aschi that this injury is sufficient in ordinary course of nature to cause death. Tenu you are causing that injury and that injury is sufficient in ordinary course of nature to cause death. Two things are there. But again, whether you intentionally cause the bodily injury to cause death to that injury or not, that is to be seen. And number two, one thing may go in your favor that if you have seen that one blow has been given on this right shoulder, vital part of the body, that it was not on any other part. Suppose you are aiming at head, but it hit on the right shoulder and it was almost cut. Then you have not repeated it. Try to repeat it. You do that and
no evidence, Mela. They're aiming to head, Mela.
no. Let us say that one blow was given when the assailant came to know that the blow was hit at the shoulder, right shoulder. He is not trying to repeat that blow on some other vital part of the body like head or any other part, but he is leaving the weapon there and going away. So in such situation, what would happen?
They're lacking of intention to kill.
No. Have you brought any citation to that effect that single blow on the shoulder portion, excessive bleeding injury, death caused?
In respect of oral declaration, I brought a decision. In respect of oral declaration, about the decision, I already cited.
What decision you have brought?
Year 1994 Supreme Court, 1994 Supreme Court, page 464. In case of Ramsay and file written note argument written note argument citation.
Cool line ta?
Oral line declaration, Mela.
Which paragraph?
Paragraph 4, Mela.
Okay, read it out, that entire paragraph.
As mentioned above, the prosecution examined PW 2, 3, 4, 5, 17, 28, and 29, and also relied on the evidence of PW's 13, 18, 20, and two others who spoke about the dying relation. Out of those died witness, the trial court relied only on the evidence PW 29, discard other. The High Court discarded the evidence of PW 29 also. Therefore, we are left only with the evidence of PW 1820, who spoke about the alleged oral dying declaration. PW 18 is the Kotwara village for the last 30 seasons. He deposed that on the day of occurrence, he was informed that A1 and others have broken the new house of Daya Prasad and killed the deceased. Thereupon, PW 18 went to the house of PW 20 and another Kotwar, and both of them came to the place of occurrence. They found the deceased was alive with injuries all over the body. Then, on being questioned, the deceased told that A1 to A3 and other persons assaulted him. In cross-examination, he admitted that they were examined on the third day only. He did not inform anybody about the alleged oral declaration. It is only on that day he disclosed to the police inspector. There is no explanation as to why he has not informed anybody earlier. He admitted in cross-examination that the deceased was not speaking clearly. He was vomiting at that time. He further added that tongue of the deceased was out of control. To the same effect is the evidence of PW20. He also came forward with this version only on Monday. Now we have the evidence of one more important witness, PW26, who is the Sarpanch of village. He deposed that after coming to know about the occurrence, he went to the place of occurrence and found the deceased lying on the cot. And he stated that he did not inquire anything from the deceased. He further stated that PW's 1820 were present. He does not say that either of them mentioned anything about the Orandai declaration. As a matter of fact, he asked PW20 to go to the police station, and accordingly, he left even at the time. PW20 did not inform him the name of the appellants said to have been mentioned by the rishis. These all are serious infirmities which we find in the evidence of regarding oral lie declaration. The medical evidence also shows that it is highly doubtful whether rishis could have made any such statement. The oral lie declaration is doubtful, important piece of evidence. Is no doubt an important piece of evidence, but it should be free from all infirmities. There is no longer no other corroboration worth mentioning.
You
Further,
see, why it was held like that? In that case, you come to the just जो paragraph 4 पढ़ुथिले तार 3-4 लाइन ऊपर पढ़ंतु. PW 34 conducted postmortem examination and found 27 injuries all over the body. Injuries resulted in the fracture of so and so, fracture of the parietal bone. Death was due to shock with multiple injuries. Injuries number 1 to 3 were sufficient in ordinary course of cause death. ତେଣୁ ୟା ଇଞ୍ଜୁରି ଆଉ ଏ ଇଞ୍ଜୁରି ଭିତରେ ପାର୍ଥକ୍ୟ ରହୁଛି ହେଲା ଏଠି ମାତ୍ର ଗୋଟିଏ ଇଞ୍ଜୁରି ସେଇଟା ହଉଛି ରାଇଟ୍ ସାଇଡ୍ ଆର୍ମରେ ଦିଆହେଇଛି ତେଣୁ ଫ୍ୟାକ୍ଚୁଆଲ ସିନେରିଓ ଏଠି ଡିଫରେଣ୍ଟ ହେଲା ମାନେ ରେସିଓ ଆପ୍ଲିକେବୁଲ ହବନି ଆଉ ତାପରେ ଏଠି ଯଦି ଅନ୍ୟମାନେ ଥିଲେ କେତେ ଲୋକ ଜାଣିଲେଣି ଯେ ସିଏ କହୁଛି ଯେ ମତେ ଏଇ ଲୋକଟା ମାରଲା ସେଠି ଏମାନେ ଆଉ କାହାକୁ ଡିସକ୍ଲୋଜ କରିବେ ତ ପୋଲିସକୁ ଷ୍ଟେଟମେଣ୍ଟ ଦେଲେ ଆଉ ଇଏ କଣ କେହି ଜାଣିନାହାନ୍ତି ହଁ ଗୋଟେ ଲୋକ ଜାଣିଲା ସପୋଜ ଇଟ୍ ଉଡ୍ ହାଭ୍ ବିନ୍ ଏ କେସ୍ ଅଫ୍ ଓନ୍ଲି PW2 ହେଇଥାନ୍ତା ଆଉ କେହି ନଥାନ୍ତେ ତାହେଲେ ଗୋଟେ କଣ୍ଡକ୍ଟରେ ପୁରା ସନ୍ଦେହ ହେଇଥାନ୍ତା ଗୋଟେ ଲୋକଟା ସେଠି ଲୁଚେଇକିନି ରଖିଲା କାହାକୁ କହୁନି ଯାଇକିନି ଶ୍ୱଶୁର ଘରେ ରହୁଛି 5 ଦିନ ଚୁପଚାପ ହେଇ ରହୁଛି ସେଠି ମଧ୍ୟ କାହାକୁ ଡିସକ୍ଲୋଜ କରୁନି ତାପରେ ହଠାତ୍ ଆସି କହୁଛି ମୁଁ ଘଟଣା ବିଷୟରେ ଜାଣିଛି ମୁଁ ଦେଖିଛି ମତେ ସେ ଏମିତି ଡିସକ୍ଲୋଜ କଲା so matter would have been different but here number of witnesses have stated those who are that at the spot and one witness has stated that while being shifted to the hospital this statement has been made accused was in a condition to speak and he has implicated the appellant to have dealt a blow by means of a weapon which is getting corroboration. So एठी dying declaration जो केस अपन साइट करछंती ता संगे एटार रेशियो देखिया गले फैक्चुअल एस्पेक्ट डिफरेंट आसी जाउछ तेनु what about the other decision you have cited?
other matter in export all year 2000 Supreme Court page 59.
Para 3 and 4.
Read that. Let us see that. Read
an oral line declaration no doubt can form basis of conviction, though court seeks for corroboration as a rule of prudence. But before the said declaration can be acted upon, the court must be satisfied about the truthfulness of same, and the said declaration was made by the deceased while he was in fit condition to make statement. The dying declaration has to be taken as a whole. The witness who deposed about such oral lie declaration to him must pass scrutiny and reliability. We are therefore called upon to examine the evidence of Period 2 and 5 to find out whether the courts below were justified in relying upon the testimony in believing the statement of alleged to have been made by the deceased while being carried to the hospital in ambulance. Thereafter, while he was in indoor patient in the hospital itself, so far a statement the ambulance concerned, it was made to PW2, who is the brother of the deceased. PW2, while was coming in a jeep towards the sense of occurrence, saw the ambulance van and therefore thought that his younger brother Hira Singh is possibly being taken in the same ambulance van and coming to know that his guess is correct boarded the ambulance van. He stated in his evidence that on inquiry about the injuries sustained by his brother, Hira Singh, the injured told him that he had been given a blow by Hikrujam Chawa Singh with a dao, the Yamlamba Paka Singh with a hockey stick, and another person with a lathi. In a cross-examination, he candidly admitted that there were 3 or 4 persons in the ambulance van when his brother told him the names of the assailant. But none of these disinterested witnesses have been examined by the prosecution to corroborate the said PW2. He also admitted in prosecution that those persons who had in the ambulance were present near him when his brother stated the word, and yet the prosecution has not offered an explanation as to why none of those persons were examined who could have been disinterested person deposing about the dying declaration said to have been made by the deceased inside the ambulance while he was being carried to the hospital. While according to the evidence PW2, deceased told him that appellant Chawa Singh gave him a dao blow, but according to PW5, to whom the deceased made a declaration in the hospital, the deceased told him that Chawa Singh, the appellant, held a thang and the Pakka Singh had a hockey stick. Instinctually, therefore, the so-called dying declaration made by the deceased to PW2 is different from the declaration made by the deceased to PW5. PW2 happens to be the elder brother of deceased. In the FR's premises, we do not think it safe to hold the evidence of PW2 to be reliable, and therefore the oral declaration as reposed to him by the him cannot be placed into service.
dying declaration dita dying declaration vary କରୁଛି ସେଟା ଗୋଟେ aspect ତାପରେ ଆଉ ଗୋଟେ ଯୋଉ aspect ହେଲା you see ଯୋଉ dying declaration PW5 ର you come to the paragraph number 4 coming to the other dying declaration
PW5 it is seen that though PW5 lost the affair after learning from his brother in the hospital, when he lost the affair, he categorically stated therein that the injured was not in a position to speak. Affair also did not reveal about the injured making declaration to the PW5.
ତାହେଲେ ଯୋଉ witness ପାଖରେ ସେ dying declaration କରିଛି PW5 ସିଏ ନିଜେ ଯାଇକିନି ଏତଲା ଦଉଛି ସିଏ ଏତଲାରେ କହୁଛି ଯେ ମୋ ଭାଇ କିଛି କହିବାର ଅବସ୍ଥାରେ ନାହିଁ ଡାଇଂ ଡିକ୍ଲାରେସନ କଥା ଉଲ୍ଲେଖ କରୁନି ତେଣୁ ସେଟାକୁ ଡିସକାର୍ଡ କଲେ ଯଦି ଡାଇଂ ଡିକ୍ଲାରେସନ FIR ରେ ନାହିଁ ଏବଂ ସେ ନିଜେ କହୁଛି ଭାଇ କହିବାର ପୋଜିସନରେ ନାହିଁ ପରେ ଆସି କହୁଛି ଟ୍ରାଏଲ ବେଳେ ବା 161 ରେ ଯାହା ବି ହଉ ଯେ ମୋ ଭାଇ ମତେ ଡାଇଂ ଡିକ୍ଲାରେସନ ଦେଇଥିଲା ବୋଲି so how that would be
ambulance ଗଲା ବେଳେ ଯୋଉ ଅନ୍ୟ କି
that is so far as PW2 we are concerned with two witnesses they have PW2 କହୁଛନ୍ତି ଯେ ambulance
9
ଏଇ ଯୋଉଟା present case ରେ PW9 ର statement ହଉଛି ये page केते number
page 60
relevant 61 para 4
deceased is the brother of PW6 Ramesh Ramesh is having a tailoring shop so and so I had been to tailoring shop of Ramesh by that time his brother Santosh came told that Nivaran so and so had dealt with his brother on being called by Ramesh means PW6. I accompanied him and went to the place of occurrence. In a car we found so and so Naresh was lying. He has sustained cut injury and therefrom he was taken to Parjang on being asked on the way so and so. এই जो case रे आपनकर this man is a disinterested witness. He is not an interested witness.
He is a friend of the PW6.
Friend of, but say जो PW2 he is a से कहले जे ये गोटे disinterested witness थिले मध्य से खाली गोटे interested witness को आइले एठी disinterested witness ନିଜେ ହିଁ କହୁଛି ଯେ dying declaration ହେଲା
para 4 my lord proclamation
ହଁ
by the time of which the deceased had sensed at the spot I did not ask deceased anything myself
ନାଇଁ
anything sir myself Ramesh and the car driver
हाँ
were present when the deceased Naresh told me
हाँ
ରମେଶ କହୁନି କି କାର ଡ୍ରାଇଭର କହୁନାହାନ୍ତି ଫରୱାର୍ଡ କରୁନାହାନ୍ତି କାର ଭିତରେ କହିଲା ବୋଲି ଭ୍ୟାନ ଭିତରେ
ରମେଶଟା ହଉଛି ତା ଭାଇ
ହଁ ପିଡଲ ଷ୍ଟିକ୍ସ
At page 54, my lord, para 13.
wait
କାର ଡ୍ରାଇଭର ନଟ୍
54.
ଏକ୍ସାମ୍
wait ହଁ
Para 13, my lord.
ହୁଁ
Parvati Sahu, myself, and Subhranshu Sahu had been to hospital by the car in which Naresh was taken. Subhranshu Sahu has also heard the deceased saying that accused Nirvana had assaulted him on the way to the hospital.
ହୁଁ
ସେ କହୁଛି ଦି ଜଣ ଯାକ corroborate କରୁଛି।
ଏଗୁଡାକ ଆପଣ ବାହାର କରିକି ଆଣିଛନ୍ତି ଜେରାରେ ଆଉ କଣ ଚିଫରେ ଯାହା ନାହିଁ ତାକୁ ଆଣିକି ଜେରାରେ ବାହାର କରୁଛନ୍ତି on the way ରେ ସେ କହୁଛି ବୋଲି ଆପଣ ଯୋଉ କହୁଥିଲେ now you got that here so only point may be that whether that blow would be sufficient to bring home the charge under 302 or any lesser punishment. Have you found, you do not found any decision?
ଆଣିନି
type already. Single blow, monu patra. Single blow, armpit karo, armpit, excessive bleeding, death, to 300 ka diyo 300 IPC ko enter let's author word single blow author word single blow type karo chalo ଗୋଟେ open ଥିଲା ପରା ଏଇଟା 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 ପରା ଏଇଟାରେ ଅନୁସୋଚ type single blow axe arm hit not feasible enter Judgment. Judgment my criminal appeal number 2043 of 2023 my lord, of Apex Court my lord, in case of Anabaj Ghan versus in state of dependent by Inspector of Police. No, you are giving you time till tomorrow. You find out those things. Yes. You also find out. Hala? Kali ki number take up kariyo. Let us not waste time. ଯେତିକ decision ଓଡ଼ିଶା ହାଇକୋର୍ଟ ସୁପ୍ରିମ କୋର୍ଟର ସବୁ ବାହାର କରିକି ମତ ହବ ହେଲା ଏଇଟା ପୁରା ପିନ୍ ପଏଣ୍ଟେଡଲି ହେଇଥିବ ଆର୍ମରେ ଥିବ କଟାରୀ କି ଏଥିରେ ହେଇଥିବ ହେଲା ଏକ୍ସେସିଭ ବ୍ଲିଡିଂ ଯୋଗୁ ଡେଥ୍ ହେଇଥିବ ହେଲା 302 କି କ'ଣ ହେଇଥିବ ଦେଖିଥିବ ହେଲା you search in 302 304 part ହେଲା take up tomorrow Mr.
Yes.
My lord, previous you also directed the rest of matter will be listed on top of the list. But
ସେ ଚାଲିଛି ଇଲେକ୍ସନ ପିଟିସନ ସମୟ ହଉନି କଣ କରାଯିବ ଆଉ ଆପଣଙ୍କୁ କିଛି ଦିନ ଧୈର୍ଯ୍ୟ ଧରିବାକୁ ପଡିବ ଆଉ କଣ କରିବା
modification of your lordship sir
ଦେਖ
I for extension of 19 को अच्छे lordship 19 melody surrender surrender date is 19
My lord, item number 14. I may be allowed to withdraw the case.
You are filing any memo?
My lord.
Acha. Item 14 withdraw. 1414.
Item number 22, the bail application, criminal appeal arising out of SCST Act 1.
Fresh matter.
Fresh matter, time permit.
ये पढ़ कर के तो ना थी कौन?
I'll wait, my lord. Let him.
Sonok, ये you serve you extra copy. Item number 22. It's a SCST matter.
Yes, ma'am.
Fresh matter. So produce the case diary and
Yes,
CDCA extra copy and confirmation letter regarding service of notice on informant. Just mark it is item number 22. Yes.
Appellant filed the interlocutory application. His daughter suffering from cancer.
Yeah.
One memo, criminal appeal number 26 of 2013, old matters. There is a substitution because the appellant died. There is a substitution with the hearing.
Lordship, on interim bail application on the ground of sister's marriage, Lordship. Sister's marriage fixed on 24th of this month, Lordship. Lordship, may I pray?
Give it. तांकू कॉपी दी चंदी
Lordship.
ए इंस्ट्रक्शन नहीं जान तो तांकू आई आउट एक्स्ट्रा कॉपी दे दियन
During course of the
बाहर कुछ नहीं दे आईआईसी थ्रू रे खबर नहीं जान तो will take list this matter it will come after one day so को थाना कौन दे दे दूं yes कौन डा कौन पाई
My lord, tried of bail matter, my lord.
Yeah.
This is the petitioner's.
Please give this.
Suffering of the serious injury, my lord. Serious illness.
You want it to be listed or not?
Listed.
Please give the memo.
Criminal appeal. Criminal appeal for bail.
And
one criminal appeal for bail.
Give it.
One bail application lordship directed to listed a week commencing 8 January.
Give it.
Pardon to mention, Lordship, item number 25, Lordship. One small modification, Lordship.
What modification you want?
Your Lordship, on dated
25 number बात करो.
Your Lordship, order dated 5/1/24, Your Lordship has directed to change the part of description of the conviction of the appellant, Your Lordship. It has been changed, Your Lordship, but the name of the appellant has been wrongly typed, which has been corrected in the order dated 3/1/24, Your Lordship. Already modified the name of the appellant, Your Lordship. It is persisting in the subsequent order, Your Lordship.
Dr.
B. Gopal Chandra Rao, Your Lordship.
It is to be made as
It has been made as Surendranath Mishra, Your
Surendranath Mishra.
Lordship. It is to be corrected as B. Gopal Chandra.
I said that it is to be read as accordingly in the aforesaid order in the subparagraph 3, where the name of the petitioner has been mentioned as Surendranath Mishra,
Yes, Your Lordship.
the same shall be read as Dr. B. Gopal Chandra Rao. So what is the problem now?
Your Lordship, last order, Your Lordship, we have applied for a modification of the description of the conviction.
Not necessary. This order covers everything. That the court has now to read in place of Surendranath Mishra, it is to be read as Dr. B. Gopal Chandra Rao. It is not necessary to score it out, anything like that. He has to read it as so and so. That order is very clear. No further modification is necessary. Yes, next. So, like the IN number so and so, correction of this so and so, not press for them. Yes, next. Yes.
Item 16.
16, what do you want?
Lordship, custody since February 2023.
After this argument is over, I will take up. Why are you mentioning?
Lordship,
Yes.
I will wait.
Item 24. I have filed an interim application on the ground that the mother of the appellant was died on 10/1/2024, Your Lordship. So I have annexed the death certificate issued by the Sarpanch, Your Lordship.
Is it coming for the first time?
First time. Last Friday I am mentioning, and Lordship directed to supply the extra copy to my client senior.
Have you obtained instruction on this?
Not, sir. We are yet to receive the. No, Veland.
I will call this matter, but see that if it is otherwise, it will come tomorrow because the mother died and to perform the obsequious ceremony. It is already 10th, means 6 days have already passed. Okay. So it's an urgent one. Just take instruction if it is possible. Okay. Yes.
आई नंबर 139 सीआरएलएमपी नंबर 296/2023 ଆପଣଙ୍କ ଅର୍ଡରଟା ଏ ପର୍ଯ୍ୟନ୍ତ ଫୁଲି କମ୍ପ୍ଲାଇ ହେଇ ପାରିଲାନି 6 ମାସ ହେଇଗଲାଣି
କି order ଦିଆ ହେଇଥିଲା?
ମେଣ୍ଟେନାନ୍ସ ପାଇଁ
ସେତେବେଳେ ମୋ ଆସାଇନମେଣ୍ଟ ଥିଲା, ମୁଁ ନଉଥିଲି। ତ ବର୍ତ୍ତମାନ ଅନ୍ୟ ଜଜ୍ ନଉଛନ୍ତି, ତ ସେଇ କୋର୍ଟରେ ଯାଇ ମେନସନ କରନ୍ତୁ, ବୁଝି ଦିଅନ୍ତୁ ଲର୍ନ ଆଣ୍ଡ କାଉନସିଲ ମାନଙ୍କଠୁ ଯେ ବର୍ତ୍ତମାନ ସେ ମ୍ୟାଟର କୋଉଠି ଆସାଇନ ହେଇଛି। ତେଣୁ
ଏଟା ସାର୍ ମଡିଫିକେସନ ପାଇଁ ଥିଲା ତ
ମଡିଫିକେସନ ଅଫ ଦ୍ୟାଟ ପର୍ଟିକୁଲାର ଅର୍ଡର, ସେଇ ଗୋଟେ ଅର୍ଡର ଯଦି ମଡିଫାଏ ହବାକୁ ଥିବ ତାହେଲେ ଅଲଗା କଥା। ମଡିଫିକେସନ ଯଦି ଥିବ ତାହେଲେ ଅଲଗା କଥା, କିନ୍ତୁ ସେ ମ୍ୟାଟର ମୋ ପାଖରେ ଆସୁନି। ତେଣୁ ଆପଣଙ୍କର ପିଟିସନ କୋଉ ଟାଇପର, ଆପଣଙ୍କର ଆଡଭୋକେଟ ଦେଇନାହାନ୍ତି କାହାକୁ?
ନାଇଁ ସାର୍
କଣ ମଡିଫିକେସନ କରିବାକୁ ଚାହୁଁଛନ୍ତି?
ସାର୍ ଯୋଉ ଏରିୟର ମେଣ୍ଟେନାନ୍ସ ଥିଲା ସେଇଟା ସେ ତ ଦଉନାହାନ୍ତି, ଆପଣ ଅର୍ଡର ପର୍ଯ୍ୟନ୍ତ କମ୍ପ୍ଲାଇ ହେଇନି, ପଇସା ନ ଦେଇକି ସେ କହୁଛନ୍ତି ଯେ ଏଟା ମଡିଫିକେସନ କରିବା ପାଇଁ ଫାଇଲ କରିଛନ୍ତି।
ତାହେଲେ ସେ ବେଞ୍ଚରେ ଆସିବ, ଯୋଉ ବେଞ୍ଚରେ ବର୍ତ୍ତମାନ
CRLMP नौचंदी सेठी मेंशन करंतु से यदि ऑर्डर हेची ताल से करेगा हैला yes.
Yes. Item 1 for only for admit, my lord.
You have no patience to wait till the
No, my lord.
what is this, a conviction matter? Yes.
Weekly list item number 26.
Yes, Mr. Kanon, please.
My lords. May it please your lordship. My lords, yesterday, I mean the last date, I had placed the material facts, the plaint, and some of the evidences relating to this part form 2B, my lords. My allegations, as your lordship knows, are threefold. So form 2B. Now I'm just quickly placing those evidences for your lordship's reference, so that because my lords, it is an admitted position that it is not exactly form 2B. The respondent also admits that he has deleted part 2 and 3A and certain other parts from
Which are not applicable to him.
which are not applicable to him. Malas, I am also, it is not my case that it is applicable to him, but it is not form 2B as stipulated by the conduct of election rules and section 33, Malas. The mandate of section 33 read with rule 4 of the conduct of election rules has been flouted.
No, I have noted down like this that even if it is not applicable to the petitioner, it should have stayed like that.
Yes,
and you should have strike it up, should not have
strike it
delete.
off. And my senior's submission that strike off and delete are one and the same meaning. It may be in common law parlance, my lords, but if it is interpreted in the specific context of the mandate of section 33 read with rule 4, it can only mean a strike off means just scoring out that relevant portion.
Mr.
Irrelevant
Kango,
portion.
Mr. Mishra pointed out from the some of the dictionaries.
Yes, my lords.
And not only that, the witness, that is the returning officer.
Yes,
he also stated that it is your witness who has stated that
True, my lords.
same. It is the meaning is same. Now, have you got anything like what is your submission?
My lords.
That even if the dictionary meaning is strike off and delete is one and same,
My lords.
but so far as the election petition is concerned, since it is a special act, then it gives a different meaning, or it has to remain as such, and you have to just score it out, not totally delete it.
Exactly on that point, my lords, we do not have a judgment. But my lords, once it is a special act, keeping in view the mandate of section 33 and rule 4, my lords, my submission is the form cannot be changed.
I just want to make a further query from you.
Yes, my lord.
Let us say that in place of scoring it out, as you said, he has deleted.
Yes, my lords.
Question is that how far it has affected the result of the case, number one. Number two, whether by such deletion can it be said that the voters who are voting, they have been withheld of some kind of valuable information?
No, my lords.
Just listen.
Yeah.
Which the petitioner is bound to give, and they withheld such information from them by deleting it, by not striking it out.
My lords, withholding of substantial information or important information whereby the voters can make an informed choice is in the affidavit itself. Here, my lords, my case is it is an improper acceptance of the nomination paper itself, which is not in form 2B. He could not have accepted it. That is my case. My lords, under scrutiny in the 36(2)(b), there is a direction that if there has been a failure to comply with any of the provisions of section 33 or 34,
Which one you will see?
36(2).
Just a bit.
36 relates to scrutiny.
Yes.
Scrutiny of nomination. Your lordships may turn to subsection 2. The returning officer shall then examine the nomination papers and shall decide all objections which may be made to any nomination, and may either on such objection or on his own motion, so moto he can also do it, after such summary inquiry, if any, as he thinks necessary, reject any nomination on any one of the following grounds. What are the grounds? 2b, that there has been a failure to comply with any of the provisions of section 33 or section 34. Now your lordships may see section 33. Your lordships may see section 33. On or before the date appointed under clause A of section 30, each candidate shall, either in person or by his proposer, between the hours of 11 o'clock in the forenoon and 3 o'clock in the afternoon, deliver to the returning officer at the place specified in this behalf in the notice issued under section 31 a nomination paper completed in the prescribed form. It has to be in the prescribed format. That is the mandate of section 33. Now your lordships may, just to refresh your lordships.
Just stop for a moment.
Yes, well.
Prescribed form he has given. Only the thing is that if I hold that the scoring out and delete is one and same, then it is in prescribed form.
Yes, my lord.
But if it is different, then it is not in prescribed form. That is
sum and substance of
right.
The issue which is to be decided.
Yes. On that particular point,
my lord, strike off and delete are two different. My lord, strike off and delete cannot be read as one and the same. Otherwise, the parliament would have used the word delete.
No.
Directly use the word.
You see, a particular word has different synonyms, right?
Yes.
So one may use it as strike off. If the meaning is same, the other person while writing it, he may use as delete. The third person may use it. That is called synonym.
Score out.
So score out. So what one person used by legislature uses in, you cannot say that this has got a particular meaning and it cannot be changed by another while writing it. If the meaning is same, okay. So beautiful. Let us say beautiful. Somebody may write it is beautiful. Somebody may say nice. Somebody say pleasing. Like
wonderful.
This. Wonderful. So question is that if the meaning is same, if the synonym is same, question is that merely and the meaning is and it indicates that the scoring of meaning and delete is one and same. So if he has taken it as not scoring of like this as you interpret, but he has deleted it, so can it be said that it is not in prescribed form?
My lords, this is also what the RO says. It has to be only in prescribed form, and that there cannot be any variation, alteration, or amendments in this prescribed form, which when it is downloaded. Para 6
at page 5.
at page 5
Deposition of arrow.
of deposition of arrow.
ठीक है यही बाबा तो ये जो जस्ट এটা স্কুইজ कर दे স্কুইজ कर खाली ये গুগলটা বার করো
Argument হচ্ছে in the context আমি কি লিখে দিচ্ছি
Yes.
Para 6.
Just a minute.
Yes.
What is that word used in that nomination paper? Strike off or
Strike off.
Strike off.
Form 2B.
O double F. Hello. Synonyms. Yes, why? Synonyms. You see, strike off ro synonyms hochi.
Yeah.
Mr. Kanungo.
Yeah.
Strike off ro synonyms hochi. Remove from a list. One. Cross off. Cross out. Take away. Take out. So these are various meaning. Mane ya mane ja ta mane se ya. ତେଣୁ ଏଇଆ ଯଦି ତାର ସିନୋନିମ୍ସ ହୁଏ ଷ୍ଟ୍ରାଇକ୍ ଅଫ୍ ର ଆଜ ପର ଦିସ୍ ଗୁଗଲ ଭେରିୟସ୍ ଆଣ୍ଡ ଏଗୁଡାକ ସବୁ ବିଭିନ୍ନ ଡିକ୍ସନାରୀରେ ତାର ମାନେ ସେଇଆ ରହିଛି ସେଗୁଡା ସବୁ ଦେଇଛନ୍ତି ହଁ Collins dictionary.com so and so Merriam Webster these are all dictionaries meaning so if the এটা বন্ধ করো ହଁ ତେଣୁ ଯଦି ଷ୍ଟ୍ରାଇକ୍ ଅଫ୍ ର ମିନିଂ ଟା ହେଲା ରିମୁଭ ତାହେଲେ how what you can say that what illegality he has committed if he has removed it or deleted it.
My lords, my humble submission is, my lords, there is a particular form. He cannot make amendments, alterations. That is also the statement of the
no, no. You say it alteration, but the statute at least that nomination paper at least authorizes him to strike it off or not.
Strike it off. Yes.
So once the strike off meaning you are initially normally as you say normally somebody would say that strike off means this.
Well.
But if we go deep into the matter and in course of the evidence which has been adduced by your witness and the dictionary meaning which they have cited during course of argument, if the meaning is that it is to be deleted or the delete meaning is the same, strike off, remove is same, take out is same. So once you take it out, remove it, then if that portion he has not kept it, then how you say that he has not strike it off, he has...
My lords, my humble submission is strike off can only be interpreted in the context of section 33 and read with rule 4. Along with the handbook of RO, my lords. There also, the form is the same. He cannot alter or amend the form. The words have to be interpreted in this context. We'll give judgments to that effect that this is a special statute and words have to be interpreted in the context of the statute. Common law, common day parlance cannot be accepted.
Yes, next.
My lords, the RO also says, para 6 at page 5.
The evidence of PW?
PW3.
PW3 tower. Who paragraph? Page ta kaun
para 6, page 5.
Page 5, para 6. I am aware about the provision of.
About the provisions of RP Act and conduct of election rules, para 7, page 6. It is a fact. Lordship gets it. It is a form that Form 2B, which is available in the handbook, Exhibit 30, is the same as Form 2B appended to the Conduct of Election Rule 61. Every candidate, Sir Paichandita, every candidate who was supposed to contest the General Assembly election of 890 Baravati Assembly constituency held in the year 2019 was required to file his nomination paper in Form 2B only, as appended to the Conduct of Election Rules 61. It is a fact that every candidate who wanted to contest the General Assembly election of 90 Baravati Assembly constituency held in the year 2019 can be permitted to file his nomination in Form 2B only, as appended to the Conduct of Election Rules and not in any other forms. Thereafter, whether
Not in any other form means 2D, 2E, the जो अन्य वाला 2B रे ही अपन को फाइल करें.
not in, my lords, once you delete a particular portion, it no longer, my lords, he clarifies it. Whether the nomination papers, question was put, whether the nomination papers filed by the respondent in Exhibit 39, 40, 41 and 42 are exactly in the prescribed Form 2B as appended to the Conduct of Election 61 in all respect. The nomination papers filed by the respondents in Exhibit 39, 40, 41 and 42 are not exactly in the prescribed Form 2B as appended to the Conduct of Election Rule 61 in all respect. Please verify nomination papers as appended to the conduct is available therein. Part 2 of Form 2B as appended to the conduct of election rules is available therein. No, it is not there. Please verify the nomination papers in 39, 40, 41 and 42 filed by the respondent and answer whether clause C2 of part 3 of Form 2B as appended to conduct of election rules is available therein. No, it is not there. Either whether you have accepted the nomination papers in 39, 40, 41 and 42 filed by the respondent, even though it is not exactly the same as per the prescribed Form 2B as appended to the conduct of election rule 61. Yes. So he himself says it is not in exactly the same form. Can you show any provision in the Representation of the People's Act, Conduct of Election Rules or instructions issued by the Election Commission of India in the handbook marked as Exhibit 38 that the returning officer has given discretion to accept a nomination paper from a candidate even though it is not exactly the same as per the prescribed Form 2B as appended to Conduct of Election Rule 61 as per the provision under subsection 3 of 4 of section 33 of the RP Act, including the proviso to such subsection. As a returning officer, I had the discretion to accept the nomination papers of the respondent in Exhibit 39, 40, 41 and 42, even though it was not exactly the same as Form 2B as appended to the conduct of election rules. Thereafter, the question was put, it is put to you that in view of the proviso to subsection 4 of section 33 of the RP Act, the returning officer has only been given a discretion to overlook any misnomer, inaccurate description, clerical, technical or printing error in the electoral roll or in the nomination paper and no other things. It is a fact. It is put to you that no discretion has been given to you to accept the nomination papers of the respondent in Exhibit 39 to 42 in the manner in which those were presented before you as a returning officer by deleting Part 2 and Clause C2 of Part 3 of Form 2B as appended to Conduct of Election Rules. Yes, I have been given enough discretion to accept the nomination papers. Is there any, well, is there again under 33? Then again the next question, is there any provision anywhere prescribed giving discretion to you as a RO for accepting a nomination paper which is not exactly the same as per Form 2B as appended to Conduct of Election Rules? There is no other provision except proviso to subsection of 4 of section 33 of the Representation of the People Act 51. The returning officer also, to your lordship's question, has put your lordship had put a question whether it is intimated to the public in general. Eta hela.
Cross-examination page 68.
Sorry, I'm sorry.
Cross-examination
at page 68.
68 पढ़ो.
68 to court.
To court.
Whether it is intimated to the public in general from which date, time and place the nomination papers for the election would be available? No. This is an incorrect statement, matlab false statement. The exhibit
AK.
Exhibit 1.
Sorry, AF1.
AF by 1.
AF.
कौन है तो को नॉमिनेशन पेपर कोठी अवेलेबल हो दिया इस तरह
In from which date, time and place the nomination papers for the election would be available दिया ही चाहिए एटा
कारण समस्त हुए तो डाउनलोड करी पारंतिनी न करिवे कार
न करिवे से किणी देखिए आगे
The lordship can see exhibit AF.
ए कौन देखो
AF by 1.
AF.
AF ना AF by 1.
AF it is signature.
अच्छा AF.
AF.
हाँ
ए फिर कौन हला
AF your lordship kindly see column 2. एक रे लिखे फास्ट एरर ओडिशा विधानसभा को 90 बाराबाटी कटक निर्वाचन मंडली रु जने सभ्य को निर्वाचन हबो. 2 तारीख 4/4/2019 तारीख सुधा जेकोसी दिन साधारण छुट्टी दिवस व्यतीत पूर्वाह्न 11 घंटिका अपराह्न 3 घंटा मध्य प्रार्थी निजे किंबा ताकर कौनसी जने प्रस्तावक मनोनयन पत्र उपजिल्लापाल कार्यालय सदर कटक स्थान रे रिटर्निंग अधिकारी किंबा सो एंड सो सहायक रिटर्निंग अधिकारी रे निकट रे दाखिल करि परिबे. उपरोक्त स्थान रे पूर्वक समय मनोनयन पत्र फॉर्म मिलिबो.
एटा होची रेलेवेंट.
So he was lying that no, it is public notice is not given.
This is AF1.
AF.
AF1 is the signature.
AF.
Notice. Column number. Where the combination and now you are placing which is it a paragraph mo jo code question ko jo
page 68.
Page 68 of cross examination of RO.
Yes.
Again, page 69 देखिए
69
of cross examination.
page ko ja.
Hi. The question is whether while downloading a nomination paper from the official website, a candidate is legally permissible to make any alteration, deletion, modification, tampering of the same and file it after filling the same. It is not permissible. Categorically says you cannot make any alteration, deletion. Then the next question, please verify exhibits 39, 40, 41 and 42. Tell which parts have been omitted by the respondent. Sorry, Manoj. Whether the official website of the election commission, ta upar question. Whether in the official website of the election commission, the form 2B in which the respondent has filed his 4 sets of nomination papers bearing such and such was available in this manner? No. Tapare, please verify exhibits 39, 40, 41 and 42 and tell which parts have been omitted. Say koidale, A parts have been omitted. Tapare, page 118. First subpara.
Wait.
As per subsection 4 of section 33 of RP Act 51 on the presentation of a nomination paper as RO, I shall have to be satisfied myself that the names and electoral roll numbers of the candidates and his proposers are entered in the nomination paper are the same as those entered in the electoral rolls. After verifying the 4 sets of nomination papers filed by the respondents in Form 2B, I find that the provision has been strictly followed by the respondent. Proviso to subsection 4 of section 33 provides that as returning officer, I can permit any misnomer or inaccurate description or clerical, technical, or printing error to be corrected, and when necessary, direct that such misnomer, inaccurate description, clerical, technical, or printing error in the electoral roll or in the nomination paper to be overlooked. By exercising my power conferred under the proviso to subsection 4 of section 33 of the RP Act, I have overlooked the alleged defects, deletion, omission in the nomination papers in Form 2B, as the same were not defects of substantial character, and such alleged defects, deletion, omissions being come under the category of misnomer, inaccurate description, clerical, technical, or printing error. As a returning officer, I have
So,
overlooked
Mr.
the same.
Kanungo, one thing, please don't forget that this is your witness.
Yes, my lords.
And your witness has stated that my exercising my power,
My lord.
I have overlooked it.
My
Had it
lord.
been the witness of the other side, matter would have been different.
No, my lords, I am, because my lords, my witness may say so, because the RO is basically holding an inquiry
You
or
mean to say that your witness is not a truthful witness?
no, my lords.
Then
Your lordships will have to examine.
why you examined witness? You want to prove the case.
My lords.
If your witness, you yourself make a submission that my witness is a deposing falsehood. My
My lords.
ଆପଣ ସେଇଆ ହିଁ
ନା
କହୁଛନ୍ତି
ନା ଆମର witness ଯେତେବେଳେ when we call him to court, my lords.
whole ଜିନିଷଟାକୁ assess କରାଯିବ ଆପଣ ଯେତେବେଳେ ଯୋଉ ପାର୍ଟଟା ଆପଣଙ୍କୁ ଫେଭର କରିବନି ଆପଣ କହିବେ ସେଟା ଫଲ୍ସ କହୁଛି ଯୋଉ ପାର୍ଟଟା ଫେଭର କରିବ ଆପଣ କହିବେ ଏଟା ଗୋଟେ ଟ୍ରୁଥଫୁଲ ୱିଟନେସ୍
No. 33(4), your lordships are to consider whether he has the powers under 33(4). He may be my witness, my lords. My witness, he is in the capacity of an official witness.
Yes, sir.
ଆପଣଙ୍କୁ ସେ ଜଣଉଛି ଯେ ମୁଁ କଣ କରିଛି, ମୁଁ କାଇଁ ଏଇ ଭୁଲ ଥିବା ସତ୍ୟ ବି ମୁଁ ତାକୁ କାଇଁ accept କଲି. Why did I accept this nomination paper? He says I have power under 33(4). Your lordships are to examine. There is a series of judgments which also says your lordship is the inquiry before the RO is a truncated inquiry. Your lordship is again sitting as an inquiring officer.
That's a different.
Now your lordships will examine whether the approach that he has taken is correct, whether it is legally permissible or not. If 33(4) he has powers to condone such omissions.
You are right that suppose he has stated
yes,
that it comes within misnomer, inaccurate description, clerical, technical, printing error.
Yes,
but if I am satisfied that this whatever the respondent has done by omitting such things
yes,
do not come within any of these things, then certainly it can be taken into account. It's not that because he has stated like that.
No, nothing, my lord.
So
it is up to your lordships to adjudicate.
Right, that is
power on him.
Two things your lordships will adjudicate: whether under 33(4) he has the powers to condone such omissions, deletions, and second thing your lordship will adjudicate whether, as my learned senior has been arguing, deletion and striking off are one and the same thing. In the context of section 33 read with rule 4. These are the two considerations your lordships have to, these are the two issues your lordship will have to adjudicate. Because the RO says something which is in my favor also. Let us say, he says something which is totally in my favor.
That advantage you can take.
No, my lords. But under law it is not
which he has been stated against you, they can take the advantage.
No, I'm saying this, my lords. If suppose he does not have, these are all flowing out of documents. It is not that, my lords,
Mr. Kanungo, it's like a hostile witness. The law is that hostile witness cannot be washed up.
No.
The part of the evidence which supports the prosecution, they can take its advantage. The part which favors the accused, they can also.
Yes, my lord.
But if the evidence is totally contrary that what he has stated, then the court may totally reject it. So neither party can. So merely because a witness is, but here the witness has not been declared hostile.
No.
Even if in cross-examination, he has given a number of answers which goes against you.
My lord.
You have not declared him an hostile. You have not tried to re-examine to clarify that position.
My lords, he is not in the because in this trial, my lords, in a civil trial, there is no concept of declaring a witness hostile.
No,
My lords, what I'm saying, he is in the capacity of an official witness, my witness, but an official witness. He is explaining to your lordship.
No, re-examination is not permissible in civil cases.
Re-examination, my lords.
Telling you that. I'm just giving an example
Yes,
of that.
well.
That hostile witness ର interpretation କଣ ହବ ବା ଇଏ କଣ ହବ ସେଇ ଟାଇପ ର ଆପଣଙ୍କୁ ଗୋଟେ ୱିଟନେସ୍ ଚିଫ ରେ କିଛି କହିଲା, ଜେରାରେ କିଛି କହିଲା, ଜେରାରେ ଯଦି କିଛି ତାଙ୍କ ଫେଭର ରେ କହିଲା, ଆପଣ କହିବେନି ନାଇଁ ସେଟା ଯୋଉ ଫଲସ ୱିଟନେସ୍, ଏଟା ଆପଣ ଚିଫ ରେ ଏତିକି କହିଛି ଆମେ କେବଳ ଚିଫ କୁ ଧରିବୁ, ଏଟା ତ ନୁହେଁ। ଓଭରଅଲ ଆସେସମେଣ୍ଟ କରିବାକୁ ପଡିବ।
ଆଜ୍ଞା, ଆପଣଙ୍କୁ ଆସେସ କରିବାକୁ ପଡିବ whether these two questions your lordships will, on this point, these two questions your lordships will adjudicate. One is whether it is the same form, and second is whether he has powers under 33.
No, he says that it is not in the same form.
Yes.
He says that he has deleted, but he says that this deletion, in spite of the deletion, I accepted it because it comes within these things, that is misnomer, inaccurate, so and so, so and so.
Yes, well.
If I find that no, it does not come within this,
yes, well,
then certainly he has not
exercised powers properly.
Correct. Okay,
yes,
that will come.
Yes, that is exactly my case, my lord. If he has powers, my lords, he has done it properly.
33 ରେ କଣ କରିବ HBR କହିଲା।
HBRO also prescribes.
Just a minute.
My lords, HBRO.
Just a minute.
Yes. And nomination paper.
Yes.
My lords, your lordships may see clause 5.11 of HBRO.
ଏଇଟା କେତେ number exhibit ଟା?
Exhibit 38 at page 75.
75.
What the RO can do under
75.
Yes, lords. Page 75 of exhibit 38. What the RO can do under 33.4.
Exhibit 38, page 75, 5.11.1. 11.1. That is the preliminary examination.
Yes.
Yes, my lords.
33.4 କଣ କରିବ ଲେଖା ହେଇଛି।
ଆଜ୍ଞା 33.4 ରେ RO କଣ କରିବ? These are statutory instructions in view of Article 324. As each nomination paper is filed, returning officer is required by law to examine it then and there from the technical standpoint as required under Section 33.4 of the Act 1951. The requiring officer is not required to hold any formal scrutiny of any nomination papers at this stage. This preliminary examination is restricted to entries relating to the name and electoral rolls details relating to the candidate and the proposers as given in the nomination papers and those entered in the electoral roll. The following aspects may be examined at this stage. If the candidate is an electoral in RO's constituency, he shall compare the entries in the nomination paper with the entries in the electoral roll relating to the serial number and name of the candidate and his proposers. If he comes from another constituency, RO or the specified assistant returning officer
Leave it next.
make sure that the electoral roll with which the RO makes such comparison to the one currently in force for the constituency. Check whether the affidavit in revised form 26 is duly filled up and attach. Check whether all columns of the affidavit are filled up. Say
That is so far that he has done, and give him that what is that checklist. Yes.
बस एतिकी से करि परिबो अंडर 33(4).
36 କହିଲା ଯଦି not in comply କଲେନି 33 has to reject at the time of scrutiny.
36 कहूची जे if he has not complied with section 33 he has to reject it at the time of scrutiny. तापरे 5.13 discrepancies and errors in electoral rolls, page 81.
81.
No misnomer, inaccurate description, or clerical, technical, or printing error in regard to the name of the candidate or his proposers or any other person, or in regard to any place mentioned in the electoral roll or the nomination paper, and no clerical, technical, or printing error in regard to the electoral roll numbers of any such person in the electoral roll or the nomination paper shall affect the full operation of the electoral roll or the nomination paper with respect to such person or place in any case where the description in regard to the name of the person or places such as is commonly understood. Returning officer shall permit any such misnomer or inaccurate description or clerical, technical, or printing error to be corrected, and when necessary direct that any such misnomer, inaccurate description, clerical, technical, or printing error in the electoral roll or in the nomination paper shall be overlooked. He has the capacity to only overlook these aspects. Returning officer has no power in law to allow any other error to be corrected. Has no power in law to... So, my lords, the inference is the returning officer has no power in law to allow any other error to be corrected. Similarly, if there's a... Lordships 5.13.2 complaint jadi haba mismatch of photo, he has the power to correct. 5.13.2 5.13.3 points which returning officer is thus required to dispose of under 33(4) of the should invariably be disposed of at this stage. It will be undesirable for RO at the time of scrutiny to reject a nomination paper for defects which could have been thus cured at the earlier stage of the presentation of the nomination form. These are the only
He has to accept close for him.
ତାପରେ ସେଇ ଜାଗାକୁ ଯୋଉଟାରେ ସେ ସେଟା କ୍ୱେଶ୍ଚନ ଯୋଉଗୁରା ଡିଲିଟ୍ କରିବା କଥା କଲା
ସେ ସବୁ ଚଳିବ ଦେଖିବି
ନାଇଁ ଆଉ ଗୋଟେ ଯୋଉଟା ରେସ୍ପଣ୍ଡେଣ୍ଟ
ରେସ୍ପଣ୍ଡେଣ୍ଟ ପୁରା ସେଇଟା କରେକ୍ଟ ଏଇଠି page 14 also. 14. It will respondent.
Then your lordships may see the cross-examination of RW1.
Go page.
Page 96. Para 114.
ଯୋଉଗୁଡାକ ମୁଁ କହିଥିଲି ଆପଣ ମାନଙ୍କୁ ଯେ
ଆଜ୍ଞା ଆମେ ନୋଟ ରେ ସବୁ
ଖାଲି just short ରେ ଦେଇଦେବେ।
note re we have quoted also ei page re ei line re
page एतिकी line from the top की type रो देई देले specified है
सर मु ताले सिनॉप्सिस आपन को बतै दोछि सो दैट वी विल नॉट
माने
वेस्ट टाइम
मन कर इश्यू नंबर जेमती से माने कहले
आय
पांचटा इश्यू एकाथरे adjudicate हेई परिबो
आय
गोटे
आय आय
हेडिंग रे तो सेही पांचटा इश्यू पई आपण को एविडेंस को रिलाय करछंती
आय
हेडिंग दे देबे जस्ट ए जो स्टेटमेंट की हला एटा जो मिसनोमर भितरे कि एटा इट इज नॉट इन प्रॉपर फॉर्म तो एविडेंस पई या ए टाइप रो खाली
आय
पैराग्राफ हमको
सेही लाइन रे
पूराटा लिखिबा दरकार नाही माने
दरकार
अगेन एंड अगेन आई एम टेलिंग अदरवाइज इट विल बी
ह्यूज
गुड
थिंग
ह्यूज तो दरकार नहीं हां
actually quote करके बतई से
हम कोट करिके कर दै छु
नहीं नहीं कोट करी बर्तमान आपण पूरा पूरा पैराग्राफ उडा लिखछन
नहीं जो पैराग्राफ रो जति की रेलेवेंट suppose page 96 है 114 para is relevant only 114 paragraph
पूरा टिपिले काहे लिखि दे
पूरा सेटा पूरा टा नुए एतिके हमें खाली कोट कर देछु ता
इज बड़ ही जो आपण 114
yes lordship can see it draft I have prepared like this
नहीं नहीं ए लाइन लाइन
I have quoted everything
कोन कि आपण माने आर्गुमेंट सरला पर आपण को मुंडरू हल्का ही गला तापरे मो मुंडर सब बोझ चली आछ ना
जो पेज गुरा आपण देखैलु सेही पेज गुरा रो कोट हेची सेही रेलेवेंट पोर्शन गुरा एई क्लॉज रे या अछि एई सेक्शन रे या अछि सेही गुरा कोट हेची
आपण इश्यू अनुଯାयी लिखछन तो
इश्यू अनुଯାयी
हां ठीक है
इश्यू अनुଯାयी
हां देन इट्स ऑल राइट
इश्यू जब ऊपर इश्यू नंबर 1 2 3
हां हां
देन 4 to 14
हां जो इश्यू गुडा को
कॉमन इश्यूज गुडा सही अनुसार
ठीक है तो कह दे
ऑलमोस्ट
यस
सारी दे तापरे RW1 भी आगे मु सिनॉप्सिस कहि दोछि आपन को तो कोट करी दे देबो
नहीं नहीं जोड़ा दरकार आपण प्लेस करंतु कि
आगे
इट्स नॉट दैट आई एम जस्ट किंतु नोट रे देला बेले टिके ये करी दे देले सेटा टिके छोटो ही जो अदरवाइज भी देखि परबी किछ असुविधा नहीं
सर पेज 96
माने करंतु लेट अस से मिस्टर दैट पेज 25 पैराग्राफ 114 फर्स्ट पैराग्राफ एति लिखले जदी गोटे जिंस हेई परची आपण पूरा फर्स्ट पैराग्राफ को आउ थरे लिखि किनी ता पूराटा को टाइप करिया किसी आवश्यकता नहीं आपण तो कहले फर्स्ट पैराग्राफ ना सो आई विल डेफिनेटली लुक इनटू दैट फर्स्ट पैराग्राफ नॉट सेकंड थर्ड सेही पॉइंट टा को इश्यू टा को ये कला यस प्लीज प्रोसीड
सर पेज 96 पैरा 114
ए 96 बार हां पैरा कोटा
114
हां
it is a fact that as per clause 5.5.1 exhibit 38 by 2 of exhibit 38 a candidate desirous of contesting the state legislative assembly election has to file his nomination in form 2b. It is a fact 38.3 is the prescribed form 2b. It is a fact that 33.1 of the RP Act also indicates that the nomination papers are to be presented before the returning officer in the prescribed form. It is a fact that in Rule 4 of the Conduct of Election Rule 61, it is stated that every nomination paper presented under subsection 1 of section 33 shall be completed in one of such forms 2A to 2E which may be appropriate. As per Rule 4, Form 2B has been prescribed in the Conduct of Election Rules. It is a fact that so far as the election in question is concerned, the relevant form for filing nomination of all candidates is Form 2B. Then the question, please verify and say whether nomination filed are exactly similar to the forms prescribed in the Conduct of Election Rules. He says, yes, it is exactly similar. Then please show where part 2 of please show whether part 2 of as prescribed in Conduct of Election Rules. Where is part 2 of Form 2B as prescribed in Conduct of Election Rule 61? And in Exhibit 38 by 3, it has been deleted in Exhibit 39, 40, 41 and 42 as Part 2 was meant for unrecognized political party and it was not relevant for me, it was deleted. Why have you not deleted Part 3A in toto as it was not relevant for you while typing nomination papers in Form 2B? Part 3A is partly relevant and I have also filled it up and that is the reason I have not deleted the entire Part 3A. Why have you not deleted second sentence of column? Sir, ସେଇଠି ନାଇଁ
ଯୋଉଟା ପଢୁଛନ୍ତି ପେଜ ନମ୍ବରଟା କହିବେ ନା
100 I'm sorry 115 page 98
ଟିକେ ରୁହନ୍ତୁ ସେଇ ଯୋଉ ସେଇ ଇଏ ୱିଟନେସ ଟା ସେଇ RW1 ର 100 କେତେ କହୁଛନ୍ତି
page ହେଲା 98 99 para 115
ଟିକେ ରୁହନ୍ତୁ 98 କହିଲେ ପୁରା
98 99
ହଁ 98 ପଢନ୍ତୁ
हाँ 98 ରୁ start ହେଲା
ହୁଁ
para 115
ହଁ para 115 at about 9:30 am ଏଇଟା RW2 ହିଁ ନୁହେଁ RW1 କୁହାହଉଛି ପୁରା
question को पढ़ो page 99 the question
para 115
तारा question
sir question why have you not deleted
page 99
page 99 ରେ question ଟା ଅଛି
ପଢନ୍ତୁ
ଆଚ୍ଛା why have you not deleted part 3A in toto as it was not relevant for you while typing nomination papers in form 2B part 3A is partly relevant and I've also filled it up and that is the reason I've not deleted entire part 3A why have you not deleted second sentence of column 2 and column 9 of part 3A of form 2B wide exhibit 39 40 41 42 it would have created confusion as I've already filled up the first sentence of column 2 and 9 part 3A of form 2B wide exhibit 39 40 41 and 42 so my lords ତାଙ୍କର ଯୋଉ interpretation ଯେ delete and strike off are one of the same things some portions they are leaving behind though it is not relevant for them then how have they adopted this interpretation ଯୋଉ portion ଆଜ୍ଞା ଯଦି strike off and delete one and the same thing so any portion which is not applicable to them ଉଡେଇ ଦେଇଥାନ୍ତେ but they are leaving behind certain portions which are also not applicable to him he admits it's not applicable but it would have created confusion then does this also not create confusion is it one and the same format so that interpretation that they are adopting
yes
my lords the interpretation which they are adopting has to be uniform in the entire form my lords ଗୋଟେ ଜାଗାରେ you say it is not applicable so I have deleted it ଆଉ ଗୋଟେ ଜାଗା it is not applicable to you you do not delete it so you are not uniformly applied this principle in fact their own witnesses say because there was paucity of time we took away these portions deleted these portions sir eta ame close kolu form eta then the judgments which they have relied my learned senior has relied upon sir segura sabu order 7 rule 11 stage re heichi order 7 rule 11 has already been answered in our favor and I will cite those judgments tomorrow my lords and show your lordships as to how these judgments have no application or bearing to this present case
tomorrow you are proposed to start from that from which portion you want to begin
aji sardebi agya 2 3 second third fourth ro small matter agya
eta next apankar kono
whether an affidavit dated 3rd could have been accepted
issue number 15 16 19 and 20
so issue number issue number
15 16
19 and 20
2019 5 8 nomination form
24/2019.
आगे
Pleading at paragraph.
my lords, we have pleaded these facts in paragraph 7b at page 8 of the election petition. I'm not placing it again, my lords. Material facts have already been pleaded. 7b, page 8 of the election petition. Their reply was no, we had
Page 4.
therefore page, my lords,
Reply in written statement.
written statement, right? Paragraph 23b from page 29 to page 30.
23 ର କୋଉ page ରେ ଅଛି?
Page 29.
29.
Page 20.
Deny
Deny କରିଛନ୍ତି.
ସେ deny କଲେ କହିଲେ ଆମେ ଯାଇଥିଲୁ, we had given an affidavit, 4 affidavits on second itself. Those were found to be defective in various manners. So with a checklist, they were returned to us, and we filed fresh affidavits on 4th. This is their stand. The present affidavit, which has been this affidavit dated, we again swore affidavits on 3rd, and we submitted it on 4th, and this was uploaded.
Also pleading ହଉଛି paragraph ହଉଛି ଟିକେ ରହିବ.
No, in addition to that, they have also adduced evidence जे जदि आपण 3 तारीख 4 तारीख गोटे affidavit आपण upload करिवे सेटा ऑटोमेटिकली 2 तारीख रो affidavit को ताकू नै जिवो उड़ेई दबो अर्थात आपण 2 और 4 दीटा affidavit दे से सिस्टम इफ टाइप रो जे जदि आपण 2 तारीख affidavit 2 तारीख upload कले तापरे से जो तांकू दिया हला जो कौन सेटा चेकलिस्ट दिया हला जे affidavit रे डिफेक्ट अछि यू रिमूव इट and they did that affidavit on 3rd, presented it on 4th रे जेतेबेले से गोटे पर्टिकुलर ईयर रे से अपलोड करूचंती what has been stated that the system is such it will not show the other one, that the earlier one.
It will overwrite.
So
Overwrite. Sir, I'll come to that.
That is why in the website you will not find the second affidavit, so also 4th affidavit. You will file only one affidavit that is dated 3, which was filed on 4th. Right?
Yes.
But the returning officer has proved both the affidavits. The affidavits dated 2nd, the affidavit dated 3rd. And not only that, once you have admitted that there was an issuance of checklist, that presupposes that there was an earlier affidavit dated 2nd. Otherwise, what is the purpose in issuing checklist?
My lords, that is a case that this has been manipulated.
सेगुडाको on admission mark is checklist गुडा.
No, with objection. Checklist ଆମ ତରଫରୁ ମାର୍କ ହେଇଛି.
ଆପଣଙ୍କ ତରଫରୁ checklist ପ୍ରମାଣ ହେଇଛି. checklist ଦେଖଉଛି affidavit 2 ତାରିଖରେ ଏୟା ଡିଫେକ୍ଟ ଅଛି. ଆପଣଙ୍କ ଡକ୍ୟୁମେଣ୍ଟ ସେ ତାଙ୍କ ଡକ୍ୟୁମେଣ୍ଟ.
ଆଜ୍ଞା ଆମରି ଡକ୍ୟୁମେଣ୍ଟ.
ତାହେଲେ ଯଦି ଆପଣଙ୍କ ଡକ୍ୟୁମେଣ୍ଟ ଦେଖଉଛି ଯେ 2 ତାରିଖରେ affidavit ଫାଇଲ ହେଇଛି, 2 ତାରିଖରେ ଏୟା ଡିଫେକ୍ଟ ଅଛି ବୋଲି ତାଙ୍କୁ opportunity ଦିଆ ହେଇଛି by issuing a checklist. So how do you say that no affidavit was filed on 2nd, for which the nomination paper should not have been accepted without any affidavit, because the affidavit is dated 3rd. So
ଆଜ୍ଞା ଆମେ ପ୍ଲେସ୍ କରିଦଉଛୁ the relevant portion.
Pleading of paragraph
Para J at page 19 of the election petition, we have pleaded.
ଏଇଟା ଗୋଟେ କଣ କହିଲେ 7B page 8 ଯୋଉଟା କହୁଥିଲେ
7B. Then para J 7J at page 19.
7J.
Regarding these issues, pleadings are in 2 paragraphs.
Okay, 7J election petition.
At
We have
page 19.
ତାଙ୍କ reply କୋଉଠି ଅଛି? 19 ଲେଖି ସାରିଲିଣି ହଁ।
ଆଜ୍ଞା
ତାଙ୍କ reply ବି ହଉଛି paragraph 23 ଯେ
ସେଇଟା explain କରିଥିବେ ଆଉ କଣ?
ହଁ
ହଁ ସେଇଟା explain କରୁଛି।
ଠିକ ଅଛି ଛାଡ଼ ତାପରେ ଏଭିଡେନ୍ସ ରେ କିଛି ଦେଖେଇବେ ଯଦି ଏଇ ଟାଇପ ର ଦେଇଦେବେ ସର୍ଟ କରି ଦେଇଦେବେ ସେଗୁଡାକୁ ଗୋଟେ ଗୋଟେ। ହଁ
33 ଟା ପ୍ଲିଜ।
ଆଜ୍ଞା 33A of the RP Act prescribes right to information a candidate shall, apart from any information which he is required to furnish under this act or the rules made thereunder, in his nomination paper, deliver under subsection 1 of section 33, or also furnish the information as to whether, not necessary, the candidate or his proposer, as the case may be, shall at the time of delivering to the returning officer the nomination paper under subsection 1 of section 33, also deliver to him an affidavit sworn by a candidate in a prescribed form verifying the information specified in subsection 1. Rule 4A of the Conduct of Election Rules thereafter prescribes form of affidavit to be filed at the time of delivering nomination. The candidate or his proposer, as the case may be, shall at the time of delivering to the returning officer the nomination paper under subsection 1 of section 33 of the Act, also deliver to him an affidavit sworn by the candidate before a magistrate of the first class or a notary in Form 26. 5.16.1 Exhibit 38 by 6, page 83.
This is
HBRO.
HBRO.
That is exhibit 2. Exhibit 38 ର କେତେ କହୁଛନ୍ତି?
Page 83.
Page 83.
ବାହାର କର 83.
Clause 5.16.1. Prescribes, along with nomination paper, every candidate is required to file an affidavit in Form 26 declaring information about criminal cases, assets, liability, and educational qualification. Each page of the affidavit should be signed by the deponent. Each page of the affidavit should be signed by the deponent concerned, or the affidavit should bear on each page the stamp of the notary, oath commissioner, magistrate before whom the affidavit is sworn. The duly sworn affidavit should be on stamp paper on such determination as prescribed under the state law of the state concerned. It would be for the returning officer to decide the validity of the affidavit in Form 26. The respondent has RW1 in his cross-examination, sir, page 46 at page 13. So just stopping here for a moment, he has to file nomination papers in the stamp affidavit. Sorry, the affidavit in stamp paper, my lords. And he also says, I am aware, because he is a famous builder, my lords, I am aware that papers, affidavits are sworn on stamp paper, so I had to give it on stamp paper. But he does not give it on stamp paper, he gives only plain paper affidavits.
Checklist does not indicate.
Checklist has been issued to them, but it does not indicate that these affidavits have been sworn on plain paper.
And he has been asked
And he has been asked to only correct certain defects in the affidavit and give it again, give it on at a later date. Now it is in evidence that he purchased the stamp paper on the it's RW1 cross-examination.
The affidavit which was filed according to them on
Yes,
2nd,
yes,
along with the, for which the checklist was issued, that was not on the stamp paper.
No.
It's a plain paper affidavit.
It's a plain paper affidavit. Your lordships were verified. The originals have been called for. Evidence real.
checklist also does not indicate. Checklist also does not indicate it is not on stamp paper.
Checklist also does not indicate that the affidavits are not on stamped paper. Though this is the first thing that any RO will write once.
Yes.
He also admits that I used to swear number of affidavits on different occasions for different purposes. The affidavits are made on non-judicial stamp paper. That is at page 13 in his cross-examination at paragraph 46.
Can you tell me that what is that exhibit that second affidavit
Yes,
the dui chariga?
Plain paper affidavit.
Plain paper.
Plain
that
paper
affidavit
affidavit.
kete?
$39 by 1, $40 by 1, $41 by 1, 42 by 1.
39 by 1.
Yeah.
40 by 1.
41 by 1, 42 by 1.
ठीक है.
And the checklists are, my lord, 39 by 2, 40 by 2, 41 by 2, and 42 by 2.
Yes.
Then in cross-examination at para 106 of page 86.
कहाँ रहो?
Respondent.
Respondent. Page 86 बार को. Back करो.
Can you tell, question is?
Yeah, just a minute. 86, yes.
Question. Can you tell when you purchased the stamp paper on which date the affidavit in form 26 was typed out as per exhibit 43? I do not remember. Can you tell who purchased the stamp paper? I do not remember. The stamp paper was purchased after verifying exhibit 43. The witness answers. The stamp paper was purchased by Sheikh Suleiman on 30/3/2009 on my behalf. Then, my lords, why, if at all it was purchased on 30/3/2019, then why did he file plain paper affidavits on the 2nd of April 2019? Then in the affidavit in the affidavit in form 26, which was filed by me on 2/4/2019 along with my nomination paper, exhibit 39 by 1 was typed on a plain paper.
Just. Yes.
My lords, when we put a specific question to him, why he did not file this when he had purchased the stamp paper on 30/3/2019, why he did not file stamp papers affidavits on 2/4/2019? The next question, can you assign any reason as to why on 2/4/2019 you filed exhibit 39 by 1 in plain paper even though you have purchased stamp paper on 30/3/2019? my advocate can reply. He evades. Now, no one has replied to this. After verifying 39 by 1 and 43, can you tell at what time you saw the affidavits? These are, my lords, not of much relevance. He says, I do not remember, I do not remember. Then the RO also admits at page 18, para 13.
RW3. RO mane PW3, sir. PW3. Page के देखो.
Page 18. Para 13.
18. 18 पृष्ठ. कुहନ୍ତୁ para 13.
Para 13 रे से कहूची, it is prescribed that stamp paper worth ₹10 is to be used for an affidavit purpose as per state law. During my incumbency as sub-collector Cuttack Southern, number of persons have sworn affidavits before me using stamp papers of ₹10. I have never allowed any person to swear an affidavit before me by using plain paper. It is a fact that paragraph 5.16.1 of chapter 5 of exhibit 38 indicates that the duly sworn affidavit should be on stamp paper of such denomination as prescribed under the state law of the state concerned. Paragraph 5.16.1. It is a fact that the affidavits dated 2/4/2019 of the respondent filed along with the nomination paper, exhibit 39, 40, 41, 42 are in plain papers. Exhibit 39 by 1 is the plain paper affidavit. Then, my lords, again your lordships may come to the question, my lords, the question is, it is put to you that the affidavits under exhibits 39, 40, 41 and 42 by 1 were not in consonance with the provisions as contained in paragraph 5.16.1 of chapter 35 of exhibit 38. I cannot say. That means, yes, sir.
If it is in plain paper, which is not at all acceptable because it requires that it should be in a stamped paper, right?
Yes.
So that is why opportunity was provided to him, and in accordance with law.
But checklist
And he rectified that defect and filed it in stamp paper with other things duly filled in.
Yes.
So you cannot say that merely because it was filed in plain paper. So
no. Say checklist. He has given a checklist.
See, your case, either you say that no affidavit filed, or you say that plain paper affidavit.
Ammo case no affidavit filed, as
Then
is
you
deflected
are now,
because. But
ବର୍ତ୍ତମାନ କହୁଛନ୍ତି plain paper affidavit filed.
ନା
argument ବି
ଆଜ୍ଞା
ମତେ ଦେଖଉଛନ୍ତି.
ନା ମୋର evidence ରେ ଆମେ କହୁଛୁ ଯେ ସେ this is to be disbelieved ଯେ that stamp paper that plain paper affidavits were filed on 2/4 because, my lords, in the checklist he does not reflect that plain paper affidavits have been given.
Either no, question is either affidavit filed at all or not. Your case is not filed. Now you are saying that it is plain paper affidavit. So you
ଆମେ କହୁନୁ ଆଜ୍ଞା. It is there.
ବର୍ତ୍ତମାନ submission କରୁଛନ୍ତି
No, ମୁଁ submission, because the documents have been called for and this is what has been revealed. That is what we are submitting before your lordships. We are saying even it is their case. If it is their case that plain paper affidavits were filed, then, my lords, they should have the checklist should contain the fact that plain paper affidavits have been filed. It should be replaced by affidavits on stamp paper. That is why we are saying that no. That is why we are saying, my lords, these affidavits have never been filed. And moreover, Election Commission website will reveal all the affidavits that have been filed.
So these documents,
yes,
were with the returning officer.
My lords, we have called for them.
You called for them.
Yes.
And it came from that particular source.
Yes, my lords.
Now, how do you say that these are all manufactured documents? It was not filed.
Because of these latches, my lords. Because of these latches. Checklist website nahi. Website देखो दी चार, that is the only affidavit which has been uploaded. fourth रे किछि uploading देखौनी. The original plain paper affidavit has never been uploaded.
checklist टा website रे रहिबो बोली provision अछि.
नहीं checklist टा तो जोटा आपन को पाखरे original टा आसीछि सेटा आपण देखिबे checklist रे first कोन करथांदा. He would have written that these affidavits have been given on plain paper.
Not in the form.
से लिखिले जे columns are not in the form, so you fill up these columns. So he doesn't write the checklists are sworn. I mean the affidavits are sworn on plain paper. So please give affidavits on stamp paper. He doesn't write that. This all shows, indicates, my lord, your lordships, if you presume, as a reasonable man will presume, this all indicates that there has been manipulation and these have been somehow introduced later on at a later stage when we have raised this question. That no such
Website रे 3 तारीख affidavit देखौछि accepted on 2nd. No note was given that he has been asked. Second note withan. Please continue.
No note. Not
Is there any column in that checklist to mention this aspect that it is not in the
All defects.
all defects.
नहीं देखो ना दी से checklist टा केते exhibit ହେଇची.
आज्ञा
Check exhibit 39 by 2.
39 by 2 गोटे देखिला आपण जानि पाइ.
Just a minute. Checklist exhibit 39 by 2.
आज्ञा
But name of the constituency, name of the candidate, date and filings, so on so. Number 1 आइला affidavit in form 26. Whether all columns filled up, if not, what are the blank columns? Whether the affidavit is shown before so and so. Certified extract of electoral roll when the candidate is so and so. Form may be applicable in the candidate sota. Copy of the caste certificate, security deposits. Could mention करथांदे सेटा.
affidavit following documents which have not been filed should be filed as
से तो आउ जोड़ी देबेनी ना एटा होची ता फॉर्म ता प्रेस्क्राइब फॉर्म.
prescribed form रे आज्ञा
कोड लिखिदांदे एटा
जे this defect रे whether filled, if there is any defect shortcoming in the document, the same should be specified. Defect shortcoming एथरे हला जे it is in a plain paper.
filed, right, yes and no.
ऊपर
If there is any defect shortcoming in the document, the same should be posted. अपन कहउछन जो एक नंबर serial रे सेपट को लिखिदांदे.
Whether filled, right, yes, if there is any defect shortcoming in the document, the same should be specified. This is a shortcoming in the document. Defect also.
Not in stamped paper बोली 8 लिखिदांदे.
8 लिखिथांते. तापर not as prescribed
ठीक
format.
नेक्स्ट आरो गुडा का दरकार नहीं सी.
हां
Sir, their own pleading in paragraph 7b, affidavit in form 26 dated 3/4/2019 has been filed on 2/4/2019.
Yes, it is.
Yes.
This is their allegation.
This is their allegation.
So that
Yes.
that affidavit is no affidavit in the eye of law. There is no pleading about second affidavit.
It should have been mentioned in serial number 1 that it was in paper and not in stamp paper. It pleading in election petition. कोटा कोले कोटा
कहते 3 तारीख से जो
को नहीं पेज केते कोंतु लाइन के
paragraph 7 page 8 and 9
para 7b
7b मैन
D to
My
D
lord.
for Delhi,
My lord.
B for Bombay.
हाँ,
B
my
for
lord.
Bombay.
B for Bombay.
7B ର କୋଉ ଲାଇନଟା ପେଜ କେତେ କୁହନ୍ତୁ?
Page 8 ରୁ start ହେଇଛି 10 ରେ ଦିଟା ଲାଇନ ଅଛି।
ନାଇଁ ସେଇ ଯୋଉଟା ଲାଇନଟା କହୁଛନ୍ତି ମତେ ସେଇଆ ଏକ୍ଜାକ୍ଟଲି ଦରକାର।
Page 9 ର 4th.
ପେଜ 9 ର
Fifth
4th ଲାଇନ, 5th ଲାଇନ
Yes.
କଣ ଲେଖିଛନ୍ତି ଟିକେ ପଢିଲେ?
ନାଇଁ ନାଇଁ ଆପଣ page 8 ର first paragraph ଦେଖନ୍ତୁ।
ଏଇ ଆଣିଲୁ ରୁହନ୍ତୁ ମୁଁ
Page 8 ର
ଇଲେକ୍ସନ
first
ସେକ୍ସନ
paragraph।
ମୁଁ ପୁରା ପଢି ଦଉଛି ଆଜ୍ଞା।
ଟିକେ ରୁହନ୍ତୁ କୋଉ ପେଜ କୁ ଆଗେ ଯିବି?
Page 8 ରେ
Page
ଆସେ।
ପେଜ 8 ହଁ।
It is submitted here that the respondent had filed his nomination paper before the returning officer on 2/4/2019 along with the affidavit dated 3/4/2019 said to be in Form 26. The nomination paper, the affidavit filed by the respondent available in public platform. It is pertinent to state that the respondent submitted 4 sets of nomination paper with affidavit as per the information available in the aforesaid web portal. The petitioner downloaded nomination paper and affidavit filed by the respondent from the aforesaid attempt to know that the affidavit along with his nomination paper filed on 2/4/2019 is of dated 3/4/2019, which is a date subsequent to the filing of the nomination paper.
Stop, take pause for a moment. तो ଆପଣ ଏଠି ଆପଣର କେସ୍ ହଉଛି ଏଇଟା ଆପଣର କେସ୍ ନୁହେଁ ଯେ 2/4/2019 ରେ କୌଣସି ଆଫିଡେଭିଟ୍ ଫାଇଲ ହେଇନି।
ଆଜ୍ଞା।
ଆପଣଙ୍କର କେସ୍ ହଉଛି ଆଜ ପର ପ୍ଲିଡିଂ ଯେ 2/4/2019 ର ଯୋଉ ନୋମିନେସନଟା ପେପରଟା ଫାଇଲ ହେଇଛି that was with the affidavit dated 3/4/2019.
ଆଜ୍ଞା ଆଜ୍ଞା।
ତେଣୁ ତାମାନେ 2/4 ଦିନ ଗୋଟେ ଆଫିଡେଭିଟ୍ ଫାଇଲ ହେଇଛି। ନାଉ ଆପଣଙ୍କର ଏଭିଡେନ୍ସ ରେ ପୁରା ଟୋଟାଲ ଡିଫରେଣ୍ଟ ଆଇଲେ ଯେ ଯେମିତି ଟୋଟାଲ କିଛି ଫାଇଲ ହେଇନି 2/4 ଦିନ ଆପଣ ବର୍ତ୍ତମାନ ଆର୍ଗୁମେଣ୍ଟ ମଧ୍ୟ ସେଇଆ କରୁଛନ୍ତି। ମୋ ପ୍ଲେନ ପେପର ଗୁଡା
ନାଇଁ ସେମାନେ it was their case ତାପରେ ସେଟା ଏଲାବୋରେଟ ମୁଁ ଆପଣଙ୍କୁ କହୁଛି
ଇଲେକ୍ସନ ପିଟିସନ ର ପ୍ଲିଡିଂ ଟା ହଉଛି is that is page 9 1 2 3 4 5 5th 6th paragraph that nomination file on नहीं अच्छा सेटा এটা actually 1 2 3 4 5 6 1 2 3 4 5 6 7 lines 7th line thus the affidavit dated 3/4/2019 along with nomination dated 2/4/2019 is no affidavit in the ଆପଣଙ୍କର ଦେଖନ୍ତୁ ମିଷ୍ଟର କାନୁନକୁ ପ୍ଲିଜ କ୍ଲାରିଫାଇ ଇଟ୍। ଏଇ ଟାଇପ ର ଗୋଟେ ଷ୍ଟାଣ୍ଡ ଆପଣ ନେଲେ ଇଲେକ୍ସନ ପିଟିସନ ରେ thus the affidavit dated 3/4/2019 filed along with the nomination dated 2/4/2019 is no affidavit in the eye of law. On a plain reading it means one affidavit was filed on 2/4/2019 which is dated 3/4/2019. Therefore, it is not an affidavit in the eye of law. This is your pleading in the election petition.
And that is my case.
That is your case.
Yes.
Now, you are advancing argument that totally no affidavit has been filed. This is your second one. Third one is, just listen and then answer.
Yes.
Third one is that on second, yes, they have filed an affidavit, but it was a plain paper affidavit. You are taking 3 stands.
No, my lords, I am not taking 3 stands. They have taken a stand in the written statement that on second we went and filed affidavits, and these affidavits there were certain defects. So the returning officer gave us, along with a checklist, returned these affidavits to us. Asked us to file fresh affidavits, and on third we swore these affidavits, and on fourth we gave these affidavits, and later on it has been uploaded in the website of the Election Commission. What I am submitting before your lordship is this is a story which has been built up because jodi plain paper affidavit diya heithanta then the returning officer would have immediately mentioned the plain paper affidavit. Affidavit.
That I have noted.
Yes, my lords. And lastly, my lords, he himself admits. Note. That is why I am submitting this. This is not my case. I am trying to dispel with their case. My pleading is no affidavit filed on second. An affidavit has been filed which is dated 3rd.
Page 14. Page 14.
So RW1, page 65. Cross examination.
Fourth line from top.
14th line from the top. Sir, apne
The
election was notified on 28/3/2019, and the last date of filing of nomination paper along with affidavits in Form 26 was there till 4/4/2019. And I filed the nomination papers on 2/4/2019, and the affidavits in Form 26 marked as Exhibit 43, 44, 45 and 46 were filed on 4/4/2019. ତାପରେ ତା ଉପରେ ସେ କହୁଛନ୍ତି
Para 61.
Paras page
33.
କୋଉଟା ଏଟା?
Page 33. Oh, page.
At page 33 in his cross-examination at para 61 has stated, page 33, cross-examination para 61 re se कहले.
Yes.
I have filed 4 sets of nomination papers to contest the election from 90 Barabati Cuttack Assembly constituency held in the year 2019, which have already been marked as exhibits 39, 40, 41 and 42. Along with my nomination papers, I have filed 4 sets of affidavits in Form 26, which have been marked as Exhibit 43, 44, 45 and 46. These are all affidavits of 3rd, dated 3rd. So he himself says, tapor line tapor
Exhibit 40 the final affidavit. So come the level put call
original and final affidavit.
Final affidavit, but where does he say that on second I have filed 4 affidavits? That has been I've been asked to replace those 4 affidavits. That is a separate issue, my lords. Your lordships are to adjudicate. No, it is my argument. Please do not interfere.
Yeah,
I'm
just a minute.
କହିଥାନ୍ତା ମୁଁ 2 ତାରିଖରେ ଫାଇଲ କଲି
Okay.
My lords, he categorically says, along with my nomination paper. He doesn't give the story there. Tapare phir again he tries to explain the final affidavit. Along with he's an educated man, my lords. He knows English well. He would have never also accepted this statement, my lords. He would have immediately said, no, it was not filed along with my nomination paper. So these are the, then my lords, the HBRO also prescribes, if there is a defect in the affidavit, then a note has to be uploaded. page 89,
Exhibit 38.
exhibit 38 ro.
HBR.
HBR ro paragraph 5.20.3.
Exhibit 38. ସେଟା page କେତେ?
89.
89 clause ହେଲା
just a minute.
ଆଜ୍ଞା
କୋଉଟା କଣ?
5.20.3
Uploading of affidavit.
uploading affidavits filed by candidates on website. The affidavits filed by all candidates, whether set up by recognized political parties or unrecognized political parties or independents, shall be put up on the website soon after the candidate files the same and within 24 hours in any event. Even if any candidate withdraws his candidature, the affidavit already uploaded on the website shall not be removed. In cases where columns are left blank in the affidavit and notice is issued by the returning officer for filing fresh and complete affidavit, the incomplete affidavit may also be uploaded on the website with a note indicating that the affidavit is incomplete and the candidate has been issued notice.
No note has been given.
No note has been uploaded in the Election Commission's website. If and when the candidate files affidavit subsequently, the same should also be uploaded on the website immediately on the same day. तो फोर्थ रे भी किछि अपलोड देखोनी only uploading date is second. Jodi, if there's what I am arguing is to dispel their argument. It is my case is kiछि affidavit diya hi and he also admits this.
No, see jota uploading heichi jota which is the affidavit dated 3 सेटा कोन देखुची अपलोडिंग हेची 2 तारिख रे
2 तारिख आज्ञा.
Lordship, kindly see exhibit.
Because that came into on 4th.
Yes, my lord.
On 4th रे upload हेले देखिवा कथा 4th रे upload.
4th रे uploaded. This has been shown as second. Lordships may see the affidavit. Exhibit.
केते number?
Exhibit 32 by 5.
32 by 5.
चारटा अछि 32 by 5, 33 by 5, 34 by 5, 35 by 5.
Just a minute. 32 by 5 टिवा. No, 32 by 5. 32 by 5. हाँ,
Right hand side application uploaded.
2nd April 2019. तापर affidavit document.
Uploaded. Left hand side affidavit.
Affidavit uploaded 2nd April 2019.
This has also been marked exhibit 32 by 6.
32 by 5, 32 by 6, 32 by...
Eta 32 by 6 हिसाब रे mark की.
आया.
This is the affidavit dated 3rd.
3rd.
अपन देखि जानतु.
Document अछि ता तळे.
Document ता तळे अछि. This was downloaded in presence of the RO also. He has gone through it. एटा आमे देछु आरो रो हला
32 by 7.
32 by 7.
account.
32 by 8, 33 by 8. RO
This was downloaded in court.
This was downloaded in court.
As per order dated.
As per order dated 3/5/2023.
No, आपण बर्तमान जोटा देखुचंदी 32 by 5.
आई.
सेटा देखुची ई एफिडेविट टा अपलोड हेची 2 तारिख रे.
आई.
बट ता तळे जोटा रहिची आपणकर नॉमिनेशन पेपर रहिची. नॉमिनेशन पेपर देखुची डेट देखुची 2 तारिख. 2/4/2019.
आई.
ता तळे जो एफिडेविट टा रहिची.
एफिडेविट टा फर्स्ट पेज रो नोटरी सील तळे डेट अछि 3/4/2019.
3/4/2019.
तापर सील
and the entire document ସବୁ page ରେ seal ହେଇଛି।
ନାଇଁ ସେଇଟା ତ ସେଇଟା ହଉଛି 3 ହଁ ୟାର ଏଭିଡେନ୍ସ ରେ ସେ କହୁଛନ୍ତି ଯେ ଥରେ ଆଫିଡେଭିଟ୍ ଯଦି ଇଏ ହେଇଗଲା
override ହେଇଗଲା।
ତାହେଲେ ଓଭରରାଇଡ୍ ହେଇଯିବ ସେଇଟା
କହିଦିଅ।
ତାମାନେ 2 ତାରିଖଟା ଅଟୋମେଟିକ କୁଆଡେ ପଳେଇବ।
2 ତାରିଖଟା କୁଆଡେ ଅଟୋମେଟିକାଲି ପଳେଇବ?
ଆରେ 2 ତାରିଖଟା ଗଲା ନାହିଁ।
2 ତାରିଖଟା କୁଆଡେ ପଳେଇବ? ତାପରେ ନମିନେସନ ଟା ରହିଲା, ଆଫିଡେଭିଟ ଟା ପଳେଇବ। ଆଜ୍ଞା ଡକ୍ୟୁମେଣ୍ଟ ଯଦି ପୁରାଟା ପଳେଇବ ଆଇ ଅଣ୍ଡରଷ୍ଟାଣ୍ଡ।
ନାଇଁ ସେ ଆଫିଡେଭିଟ୍ ଟାକୁ ଇଏ କରୁଛନ୍ତି ନା, ଆଫିଡେଭିଟ୍ ଟାକୁ ଡାଉନଲୋଡ ଇଏ କରୁଛନ୍ତି।
ଆଜ୍ଞା ଏଟା ସିରିୟଲି ରହିଲା,
document
ଡକ୍ୟୁମେଣ୍ଟ ଟା ସିରିୟଲି ରହିଲା। ଆଉ ୟୋର ଲର୍ଡशिପ୍ସ ମେ କାଇंडली सी करंट स्टेटस ସେଇ ଫ୍ରଣ୍ଟ ପେଜ ଟାରେ करंट स्टेटस
date ଟା ବି override ହେଇଥାନ୍ତା।
accepted ଲର୍ଡशिପ୍ସ ଏଟା accepted। ଯଦି ଓଭରରାଇଡିଂ ହେଲା ତାହେଲେ ଡେଟ୍ ଟା ଓଭରରାଇଡ ହେଇ 4th ପଳେଇଥାନ୍ତା। पूरा जिनस एप्लीकेशन अपलोडेड 4th एप्रिल, एफिडेविट अपलोडेड 4th एप्रिल।
order upload होची order date देखो।
हमर जो हाई कोर्ट ऑर्डर आगे अपलोड होची से ऑर्डर डेट देखौची। जदी सब्सिक्वेंट अपलोडिंग डेट ता देखौची। आ
जदी ओवरराइड करथांता,
जदी ओवरराइड करथांता
फुल पेज रू जाइथांता नॉमिनेशन,
फर्स्ट पेज रू पळैथांता नॉमिनेशन।
that it indicates that ଦିଟା ଯାକ ମଧ୍ୟ ରହିବା ଉଚିତ ଯେ
ଦିଟା ଯାକ ରହିବା
ପ୍ରଥମଟା ଯଦି ଭୁଲ ଅଛି ତାହେଲେ ସେ ଭୁଲଟା ବି ରହିବ ଏବଂ ଗୋଟେ ଲେଖା ରହିବ ଯୋଉଟା କି ଆପଣ ଚେକ୍ ଲିଷ୍ଟଟା ଯୋଉଟା କହୁଛନ୍ତି ଯେ ତାଙ୍କୁ କୁହାଯାଇଛି ଯେ ଏ ଡିଫେକ୍ଟ ଗୁଡାକ ଏଇଆ ରହିଛି ତାକୁ ରେକ୍ଟିଫାଏ କରିବାକୁ ଏତିକି ଦିନ ଭିତରେ ଆଣି ଦବା ପାଇଁ, ସେଇଟା ବି ମିସିଂ କରୁଛି।
ସେଇଟା ବି ମିସିଂ सर। मोर सेही ପାଇଁ my specific plea is जे third affidavit has been uploaded माने has been filed on along with nomination on 2nd। that is why they have uploaded knowledge current status accepted केमती देखिबो। Election Commission of India re again the common public along with me, I am also a part of the common public। I am to get relevant information। first affidavit रे कौन से लिखिची कौन लिखी नहीं किछि तो that affidavit has never been uploaded। and jodi tako story is believable and this is the only affidavit which has, and he makes a bold statement there was an overriding means the entire thing has to go। and my lord the date 2nd ta 4th heitanta, overriding hela 4th heitanta। how can 2nd remain 2nd?
document affidavit
no ସେଇଟା application uploaded ହେଇଛି।
ଆଜ୍ଞା
ସେଟା application uploaded
application uploaded
affidavit portion ଟାରେ ଯୋଉ 2 ଲେଖା ହେଇଛି ସେଇଟା ଆପଣଙ୍କର ଏଇଟା ସେଇ ଯୋଉଟା
ସେଇଟା
ରାଇଟ ହ୍ୟାଣ୍ଡ ସାଇଡ ଟା ଠିକ ଅଛି, application upload ହେଇଛି 2 ତାରିଖରେ।
current status ଟା ଆଜ୍ଞା ଦେଖନ୍ତୁ 2nd ଏପ୍ରିଲ ରେ ଯଦି ତାଙ୍କର affidavit ଟା defective ଥିଲା ଯେ plain paper affidavit ଫେରା ହେଇଗଲା, how can they write accepted?
that means that application was okay but the affidavit was defective for which
na eti note deithanda na agya। how can it be said to be accepted? Nomination has been accepted and my lords he is the only person, he has admitted in his evidence that he is the only person to upload these documents under his digital signature। jodi eya habo tale se accepted lekhile kemti?
that has been explained, kindly take these exhibits।
my lord ଦି ଜଣ କ୍ୟାଣ୍ଡିଡେଟ ଙ୍କର ଆଫିଡେଭିଟ ଡିଫେକ୍ଟିଭ ଥିଲା, ଗୋଟେ ରେସ୍ପଣ୍ଡେଣ୍ଟ କର, ଅନାଦର କ୍ୟାଣ୍ଡିଡେଟ ହଉଛନ୍ତି ପ୍ରିୟଦର୍ଶନ ପାଲେ। ତାଙ୍କର ମଧ୍ୟ ଅନରେବୁଲ କୋର୍ଟ କୁ ଆମର ଆପ୍ଲିକେସନରେ ଏଇଠି କୋର୍ଟରେ ପ୍ରିଣ୍ଟ ଆଉଟ ବାହାରିଥିଲା 20/7/2023 ରେ। ସେଟା ଏକ୍ସିବିଟ DU ହେଇଛି, DU/1 ହେଇଛି କଭର ପେଜ ଏବଂ DU/2 ହେଇଛି ଦି ପର୍ସନ showing the affidavit uploaded on 29 March 2019।
please note it down so that when you argue you just clarify it।
In our argument we have already
you are getting a chance after him to
okay
note down that would be better। Mr. Kanungo,
yes,
we have to take because matters are there with
my lords tomorrow I will
ଏଠିକି ସରିଗଲେ ଏଇ 4ଟା ଏକ୍ସିବିଟ ହେଲେ ଏ ପାର୍ଟଟା ସରିଯିବ। ଏଇ ଏକ୍ଜିବିଟ ଚାରିଟା
କେତେ
ଦେଖିଦେଲେ
ସମୟ ନେବେ ଆଉ?
ଏଇ 10-15 ମିନିଟ ସରିଯିବ ଖାଲି ଏଇ
Because,
ଡକୁମେଣ୍ଟ ସିମିଲାର ଡକୁମେଣ୍ଟ
there are number of matters I am to
Yes.
ଖାଲି ୱାନ୍ ଲାଇନରେ କହିଦଉଛି ମୁଁ
Hmm.
ଏ ଯୋଉ ଆଜ୍ଞା ଏକ୍ଜିବିଟ 32/5 32/6 ଦେଖିଲେ
Hmm.
same document they have also marked exhibit W/1 to W/8
Hmm.
same thing has been mentioned.
Hmm.
Affidavit application uploaded on 2nd April, current status accepted, affidavit uploaded on 2nd April 2019.
Hmm.
And a copy was downloaded by this honorable court in court, and that also shows same.
But there is some kind of clarification which
Regarding overriding.
Oh, sorry.
Milord, if this is one PDF document, this document was in one PDF uploaded. If override ହେଇଥାନ୍ତା ଆଜ୍ଞା ସେ either first page ରୁ ହେଇଥାନ୍ତା କି last page ରେ ହେଇଥାନ୍ତା ସେ ଠିକ ମଝିରୁ nomination ପରେ କେମିତି override ହବ? Override ହେଲେ ପୁରା top ରୁ ହବ କି ତଳେ ହବ? But ସେଇ middle portion affidavit portion ଟା exactly କେମିତି ହବ? It's in PDF form uploaded, and Election Commission has directed even if a defective affidavit it cannot be removed. There is instruction in the HBR. And we have also put, if he knows it was system was overriding, he should have again re-uploaded, or he should have intimated to the election. He said, I have not thought it proper to intimate. He was working under the Election Commission of India. He should have intimated to the Election Commission that system is functioning such. Because Commission has mandated that once affidavit uploaded, it should not be removed. Override hele, he should have intimated to the Commission.
He has given explanation or finding fault with the system itself.
Yes.
Yes, sir.
System is such that once you do this,
It will be, and it is his own digital signature. And my lords, how can he show the nomination accepted on 2nd if the affidavit itself was defective? Could not have. ଲେଖା ହେଇଛି accepted. ଯଦି ଆଉ କିଛି ଥିବ ସାର୍ ଆମେ କାଲି କହିଦେବା ଏଇ aspect ଉପରେ. Then tomorrow we will apprise your lordships about false affidavit and the law as on date.
ସେଇ ଡାକ୍ତର କାଟିକି ସେ ଦୁଇଟା ବେଳେ ରହୁଥିବେ ଆଉ ସେ ଅନ୍ୟ ମାଟରଟା ସେ ଡିସପ୍ଲେ ବୋର୍ଡରେ ଦେଖାଅ ଅନ୍ୟ ମାଟର ଚାଲ
Weekly list item number 1.
ସେ ମ୍ୟାଡାମ କଣ କହୁଛନ୍ତି ଆପଣ କଣ ହେଲା ପୁଣି କଣ କହୁଛନ୍ତି ଏଇ କଣ ସେ ଆଣିଲେ କଣ କହୁଛନ୍ତି just କଣ ଆପଣ କହୁଛନ୍ତି
ସାର୍ ଆପଣଙ୍କ ଅର୍ଡରଟା
ହଁ
ଓପି ଏଟା ମଡିଫାଇ କରିବା ପାଇଁ ଦେଇଛନ୍ତି,
ହଁ
ମଡିଫିକେସନ କରିବା ପାଇଁ ଦେଇଛନ୍ତି। ଆପଣଙ୍କ ଅର୍ଡରଟାକୁ ମଡିଫିକେସନ କରିବା
ଏଇ ଯୋଉ ଅର୍ଡରଟା ଆଇଏ ନମ୍ବରଟା
ଚାଇ ନମ୍ବର ଦଉଛି। ସତର 3/23 ଅର୍ଡରଟା ସାର୍।
କଣଟା ମଡିଫାଇ କରିବାକୁ ଦେଇଛନ୍ତି କାଇଁ ଇଣ୍ଟ୍ରିମ୍ ଆପ୍ଲିକେସନ କାଇଁ ଯୋଉଟା ମଡିଫିକେସନ ପାଇଁ ଦେଇଛନ୍ତି ଏଇ ଅର୍ଡରଟାକୁ 19/12
ମଡିଫିକେସନ କରିବା ପାଇଁ ସାର୍ ଏଟା ମୁଁ ଦେଇନି,
ଆଉ
ଓପି ଦେଇଛନ୍ତି।
ହଁ this is an application for modification oblique clarification of the order dated so and so ହଁ ଶୁଣନ୍ତୁ ଆଚ୍ଛା 17/3/2023 ଅର୍ଡରଟା ମୋର ଥିଲା।
ସାର୍ ସେଥିରେ ସାର୍ କପିଟା ଆଟାଚ୍ ହେଇଯାଇଛି। ଆନେକ୍ସର 1 ରେ।
ଟିକେ ରୁହ। ଏଇଟା ମେମୋ ରଖିଲ ମେମୋ ଗୋଟେ ଦିଅନ୍ତୁ ମ୍ୟାଡାମ।
ଆଜ୍ଞା ସାର୍।
ମେମୋଟା ଦିଅନ୍ତୁ କାଲି ଆଣି ଦେଇଦେବେ ଯଦି ଆଜି ଲେଖି ନାହାନ୍ତି କାଲି
ମେମୋ ବି ସାର୍ ଏତେ ଲେଖି ଦେଇଥିଲି।
ହଁ
ମେମୋ ବି ଲେଖି ଦେଇଛି। ମେମୋ ସହିତ ଆଫିଡେଭିଟ୍ ବି ଦେଇ ଦେଇଛି ସାର୍।
କୋଉଠି ମେମୋ କାହିଁ?
ଫାର୍ଷ୍ଟ ପେଜରେ।
ଏଇଟା ଦେଇ ଦିଅନ୍ତୁ। ସେ ତାଙ୍କର ପର୍ସନ ଇନ୍ ପର୍ସନ ଯେହେତୁ ଆପିୟର କରୁଛନ୍ତି ସେଇ ବେସିସରେ ଏଇଟା ମୋ ଅର୍ଡରଟା ତ ମୁଁ ମଡିଫାଏ କରିପାରିବି ଠିକ ସେ କହୁଛନ୍ତି ହେଲା 24th ଆଲାଉ କରିଦିଏ ନାଲି ଚିହ୍ନ ମାରିକି ଦେଇ ଯାଆନ୍ତୁ 24 ତାରିଖ ଦିନ ଆସିବ।
24 ତାରିଖ
ୟେସ୍
24 ତାରିଖ ସାର୍ ଆସିବି ତ?
24th ଆପଣଙ୍କର ତାରିଖ ଫିକ୍ସ ହେଲା ଆପଣ ଲେଖିଛନ୍ତି 24 ତାରିଖରେ 24 ତାରିଖରେ ଆସିବ ଯାଆନ୍ତୁ।
ହେଲେ ଅପିଲ ବେଲ୍ ମ୍ୟାଟର ଦିଟା ଆଜିକୁ ଆର୍ଜନ ଥିଲା।
ଦିଅନ୍ତୁ।
Item 1.
May I please your lordship? Lordship, case of conviction under NDPS Act, praying for admit. LCR made available by CRLA number 462 of 23.
What is the conviction and what is the sentence imposed?
20 years of imprisonment and
61. Okay, hard admit call for the trial court record. It is submitted by the learned counsel for the appellant. The trial court record has been called for in CRLA number
462
of 2023. Registry sir, verify the same and proceed. Yes.
Item 2.
May I please, your lordship? I have been imposed sentence to undergo rigorous imprisonment for 3 months and to pay fine of rupees 3,000 in default to undergo further arrest.
Learned counsel operative part is
Page 20.
page
20.
20.
89.
29, no? 17 no trial court judgment. 489. The convict is for his conviction under section 489C, sentenced to arrive for 3 months to pay fine of rupees so and so. So it is for 3 months, Mr. Okay. And you are on bail during trial.
Yes, your lordship.
Okay, hard Mr. Pradeep Kumar Bihar, learned counsel, appearing through virtual High Court Kalahandi at Bhavani Patna. Admit call for the trial court record. He was on bail. Bail allowed. Stay realization of fine. Yes.
Yes, ma'am.
Item 3. Item 5.
May I please, my lord? Offense under section 363, 366, 376, 2N and 506 of IPC and under section 6 of POCSO Act. Maximum punishment, my lord, 10 years, my lord.
Operative part.
Yes, my lord.
Operative part of the judgment where the sentence.
Page number 55, my lord.
55.
55, my lord.
55 no judgment sorry running page kete yo internal page kete phone do
43, my lord.
43 10 years na.
Yes, my lord.
Right, admit call for the trial court record, then so and so shall be considered after receipt of the trial court record, deposition copy to be supplied. Yes, next.
Oh, bless me.
Item 6.
May I please, your lordship? The offences under which the accused is convicted are 304, 304B, 498A. And he is sentenced for 14 years. And he's already in 10 years, rigorous imprisonment of 14 years, and already in jail for 10 years.
All right, admit call for the trial court record. Interim application so and so shall be considered after receipt of the trial court record. It is submitted by the learned counsel for the petitioner that appellant could do that out of 14 years of substantive sentence imposed by the learned trial court, the appellant has already undergone 10 years of sentence. Let the learned counsel for the state obtain the custody certificate. Deposition copy to be supplied. Yes.
Obliged, madam.
Item 7.
May I please? This is a case under PC Act. Petition offense is section 7 for 2 years and under section 13, 2 and 13 1D, that is 3 years. Both the sentences shall run concurrently.
You were on bail during trial.
My lord, bail, he is in custody, 2 persons. Another person was present on the date of judgment. He was released on bail. Thereafter,
No, I am telling about Lakshmi Narayan Satpathy.
my lord, he is in custody on 2-1-2024.
Just a minute. Okay. No, during trial you were on bail.
Yes, yes, bail.
After conviction?
He is in custody on 2-1-24.
No, for this offense you should have been let out on bail because 3-year sentence is there.
My lord.
He was absent on the day of judgment. NBW was issued. He was arrested pursuant to the NBW, and now he is in custody.
Oh, that is all right. Because
and appeal is 1359 of 2023. Your lordship has been pleased to admit the appeal. Call LCR has been called for.
Of another accused.
1359.
Right.
The judgment is
all right. Admit call for the
out of 2 accused. 1359 2023. Appellant has been enlarged on bail. Appeal has been admitted.
Judgment is
Mr. Sanjay Kumar Das, Land and Standing Counsel, submit that he will file his appearance memo. And he was on bail during trial. And on the date of pronouncement of the judgment, he remained absent, for which non-bailable warrant of arrest was issued. Subsequently, you were arrested or voluntarily surrendered?
Surrender.
Voluntarily surrendered before the trial court, and he has been taken into judicial custody. So bail allowed, stay realization of fine. Mr. Das submits that this criminal appeal is connected to CRLA number
1359 of 23.
1359 of 2023, in which trial court record has been called for. Henceforth, this criminal appeal will be listed along with CRLA number 1359 of 2023. Free copy of the order be handed over to the learning standing grounds. Yes.
I will file my appearance by the end of March.
So let's
admit. Stay fine. Yes.
Item 8.
Operative part at running page 50, para 54, your lordship.
3 years 10,000 in default 2 months. Okay, then so and so 2 years 5,000 in default so and so run concurrently. Okay, so the highest one is 3 years.
Your lordship.
You were on bail during
Yes,
that. Yes, Mr.
Yes, ma'am. Same. So, I'll file my appearance.
Bail granted. Appearance memo to be filed. Stay fine. Free copy of the order.
Obliged, Your Lordship.
Obliged.
Item 9.
Item 9, that against conviction, internal page 18, my lord. Under section 324 IPC, RI for 3 years and fine of rupees 5,000.
Page के दें?
Page 18. Internal
Running
page.
page or internal?
Running page 24, my lord.
24.
Yes, my lord.
RI for 3 years, 324, 5,000. Then RI for 1 month. Okay.
341.
7 days, all right. You are on bail.
Yes, throughout on bail.
Admit you was on bail, bail granted. Stay realization of fine.
Not like that.
Yeah.
Item 10.
May I please, Your Lordship, in this case, during the trial stage, appellant was on bail.
You know, what is the sentence first?
Sentence, page 53, 10
10
years.
years. All right.
Aguru bail le thila.
Call for the trial court record. Interim application for bail and stay realization of fine to be considered after receipt of the trial court record. Deposition copies to be supplied to the land and council for the state. Yes.
Xerox दे दो सर.
दियो मु तो ऑर्डर कर दिली अपन जेबे अकाउंट पर.
Item 11.
Yes.
At page 67. Here what I raised a point of law. Because Nilachal Multipurpose Cooperative Society Limited is a registered cooperative society and is controlled by the ARCS. And your Lordship kindly have a glance to the section 2D of the OPID Act. Section 2D of the OPID Act, there is an exception to the registered cooperative society, which society is owned or controlled by the state government. I raised that point before the land trial court. Trial court has observed it will be considered during trial without examining the issue whether OPID 6 of the OPID Act will attract or not. Simply said, this aspect will be considered during trial. And so far as allegations involvement of present petitioner is concerned, the present petitioner was the president for a particular period. Prosecution has not come out to a case that during my incumbency as a president, some irregularity, financial irregularity has happened. Rather, I am a victim because I invested money 25 lakhs. Out of 25 lakhs, I have received only 9 lakhs. 16 lakhs is still pending. And so far as PID Act is concerned, my lord knows that I have this, my lord, multi-purpose cooperative society has not collected a single pipe from the general public. Here the employees took a decision and collected money, and they use for their purpose. I have not, my lord, this society has not collected a single pipe from the general
That
public.
will be known when he will from the charge sheet it will have been fine.
Discharge petition, I discharge petition.
No, charge sheet रे कौन तार आपनकर finding अछि.
चार्ज शीट से आवेदन किछि लिखु ना सेठे भी किछि लिखु ना 1738 रो ओपन रख देकी रख देछन चार्ज शीट रे भी से पार्ट रे किछि लिखना. Let us decide whether OPID Act will attract or not. If OPID Act will not attract, some other offences are there, so it will go to the.
Come taken next week. Learn, Mr. Patro, JP Patro and Council submit that he has received the copy of the appeal memo and seeks some time to obtain instruction. Put up this matter next week. Name of Mr. Vivekanand Bhuiya and Mr. JP Patro shall be reflected in the cause list henceforth. Yes.
Only for the difficulties, tomorrow is the framing of charge.
There is no problem. Even if charge is framed, it can be amended. So it is coming next week. Just yes.
Item 15.
15, Mr. Mahanti.
May I please, Lordship? This is the second journey of the petition, Lordship.
You have received the case diary?
Yes, my lord.
Your first application was rejected or withdrawn?
Dismissed on merit, Lordship. And there was
that order?
There was a direction to expedite the trial and on the first instant examine the material witnesses. In the meantime,
what is the change?
Change the material witnesses has been examined, Lordship.
Have you supplied the deposition copy?
Already the discussion in the rejection or result, they have support to the prosecution.
What is the offense here?
302, Lordship.
302.
Yes.
So what do you want? The witnesses have supported the prosecution case.
Petition is in custody, Lordship, in 26/5/2020, Lordship. Lordship,
Mr. Where is that the deposition copies?
He has not supplied.
Supplied what?
So he supplies that deposition copy. They have a right to. Learn and counsel for the petitioner submitted that when the petitioner earlier approached this court for bail in what is that number? BLAPL.
CRLA, Lordship. The ELL CRLA 335 of 2021.
Court लिखिଛନ୍ତି ଆପଣ ए
certificate
first title ତ ନାହିଁ?
ଅଛି ଲେଖା ହେଇଛି ଲେଖା ହେଇଛି ସାର୍ଟିଫିକେଟ ଅଛି CRL 335 of 2021.
କୋଉ ଏଟା ବାହାର କରୁଛନ୍ତି ଯେ 81 କଣ?
Item 15 ଲସ 15 item 15 ଲସ 572 of 2023.
Just a minute. Earlier approached this court in CRL number 335 of 2021. Same was rejected as per order dated 24/1/2023. And it was observed that the petitioner liberty was granted to the appellant to renew the prayer for bail after examination of material witnesses. Stop. Learn counsel for the appellant further submits that in the meantime, material witnesses have been examined in the trial court, and that is how he has filed this second bail application. Land counsel for the state, however, submitted that though
notice has been served. Notice has been served.
Though notice has been served and he has received the case diary, but the deposition copies have not been served on him. Deposition copies of all the witnesses examined so far be handed over to the London Council for the state. Aji debe by tomorrow.
Next week debe.
By next
week.
Baki nahi. Ketara sakhi achi?
Sakhi 6টা ହେଇଛି discussion ହେଇଛି rejection order ରେ.
Rejection order kon 8ଟା ଦେଖୁଛି ଆଉ 6ଟା. So serve the deposition and also for the court also. Okay. So It will come in the week commencing then 29th. Yes.
Probably.
Item 16.
Mr. Panda, Prashanna Kumar Panda.
That's it.
Yes.
Offense under section 376 2L 294 320.
Notice sufficient? Just a minute,
Yes,
I'm
ma'am.
asking him.
Yes.
So, is it the first application or earlier rejected?
First application.
First application.
And the
So-
motion against the
CD is not available.
Oh,
but all the copies of the CD certified copy along with the medical.
let him. Why have you? It was filed on 7/8/2023. Why have you not obtained the case diary? Obtain
Yeah.
it. Will take up this matter
Yes.
next week. Put up this matter next week as prayed for by the Land Council for the state. Who though submits that notice on the informant. You are entering appearance.
My lord.
Okay, then it's
In favor of the informant, the victim well meant.
all right. आपन को power file करना दी.
Today I filed.
अच्छा, so and so files power for the victim which is taken on record.
My name may be
And
recorded.
have you received the? You must have received the copy of the appeal memo and not received.
Yes.
Acha. The Learned Council for the state seeks some time to obtain the case diary. Put up this matter next week or then. Yes, next.
Item 17.
I for Honorable 5 Limitation Act 275 delay my lord.
What is the CRLA for?
14 day of application, bail job matter my lord. The petition was on bail my lord.
Wait. What is the delay pointed out by the stamp report?
275.
So notice has to go because in such type of cases,
And 3 SC Act is there.
notice has to go. So you serve an extra copy of that. Let an extra copy of the CRLA along with IA be served on the Land Council for the state, which will be sent to the IAC of
Dhenkanal Sadar.
Sadar Police Station for its service and the informant in so and so case number one. Matter to good saptah pare pakei diyantu hala. Yes, extra copy of CRLA, so also IA. Is served. Yes.
Item 18.
18, Mr. Raut Rai. The other request diary by
Yes, status report was called for.
status report the ACH. अच्छा non appears कर दियंतु. Land Council for the state submits that he has received the case diary. Put up this matter. Go to saptah pare pakei diyantu. Non appears for the appellant. Yes, next.
Item 19.
Yes, my lord. The appellants, my lord, earlier filed CRLA before this honorable court.
That is 111 of 2022.
My lord, and
another 196.
2022.
So it's a single appellant.
No, two jana.
हाँ.
And
this
both
application was earlier rejected.
Both appeal had together and disposed of 4/4/2023 by a common order, my lord.
Where is that order copy?
Order copy, my lord, and wherein directed this honorable court renew the prayer after examination of the victim.
Just a minute.
I have filed the.
Take ରୁହନ୍ତୁ. Do well to expedite the trial. Appellants are at liberty to renew their prayer for bail after examination of the victim. Right. What has happened? Victim examined.
My lord. And
So,
this is certified.
have you
copy?
supplied deposition copy?
Yes.
Support kala.
Yes.
Victim supported the prosecution case or not supported? Mr. Tripathi?
Yes, was supported.
ଆପଣ କହୁଛନ୍ତି ମୁଣ୍ଡ ହଲଉଛନ୍ତି?
No, my lord. Supported ମାନେ ଏଠି
ଦିଅନ୍ତୁ ଆରେ deposition copy ଟା ଦିଅନ୍ତୁ. ଫାଇଲ କରିନାହାନ୍ତି deposition copy?
ଫାଇଲ କରିଛି my lord.
କେତେ ନମ୍ବର ପେଜ ରେ?
My lord. ଏ certified copy ଦେଇଦଉ.
ଦିଅନ୍ତୁ certificate.
PW1.
ଏଇଟା ଲାଇଭ ଷ୍ଟ୍ରିମିଂ କରୁନୁ ତ?
Item 20.
Conversion of so and so CRLA to so and so. এটা কি দেখিয়েছি কি ডিফেক্ট দেখিয়েছি? Being aggrieved so and so. এটা অফেন্স কোন কি? BLPL কাହିଁ ହବ ବୋଲି ସେ ପ୍ରେୟାର କରୁଛନ୍ତି?
376D is there.
No, no, no. BLPL CRLA ହବନି ମାନେ କଣ? SC ST ନାହିଁ କି? This is item number 20.
My lord, SC
ଗୋଟେ IA file ହେଇଛି ନା?
SC 9.
SC ନାହିଁ?
Presiding judge SC ରେ ସେଥିପାଇଁ ବୋଧେ ଫାଇଲ କରିଦେଇଛନ୍ତି
ଆଁ?
ଯେହେତୁ କୋର୍ଟ ଅଫ ପ୍ରିଜାଇଡିଂ ଅଫିସର ସ୍ପେସିଆଲ କୋର୍ଟ SC
ନା ମ ସିଏ ତାଙ୍କ ପାଖରେ ଅନ୍ୟ ମ୍ୟାଟର ସିଏ ନଉଛନ୍ତି SC ST ନାହିଁ ତ ଯିବ but he has mentioned in that
now file I also
ହଁ
conversion
ଯେ ମୁଁ ଚାହୁଁଛି ଯେ ଚାର୍ଜ ସିଟ୍ SC ST ରେ ଫାଇଲ ହେଇନି are you sure?
charge sheet copy ne rejection order copy shows SC ନାହିଁ charge has been framed under section
Bill who is in
365.
custody so and so.
Para 3 of the rejection order.
All right. IA number so and so. This is an application for conversion of so and so after going through the averments taken in this so and so. And since the rejection order indicates that charge has been framed under section 365, 323 and 376D of the Indian Penal Code, I'm inclined to accept the prayer made in this interim application. Accordingly, the CRLA be re-registered as BLAPL and be placed before the assigned bench. Yes. Next.
Item 21.
Trace SC.
Extra copy to be served, notice to be issued, CDCA to be obtained. Okay. Yes. Next.
Item 23.
23, Mr. Khotwa.
23.
What is this CRLA for?
CRLA against the order of the learned ADJ from Special Judge Jashpur, my lord, in allowing a petition filed by the prosecution under section 319. That is under challenge, my lord. What I beg to submit, my lord, today I am filing the copy of the deposition of witnesses for
also supply to the state council.
State is not a party.
State is not a party.
I am appearing for the informant.
Okay.
State is also a party, opposite party number 2.
हाँ अच्छी तो फाइल नहीं तो आपण कॉपी टे सी दे देबे assume the land council for the appellant serve the copy of the deposition on the land and council आपण copy देबे
काली दे देबी एटा कोर्ट रे
filed deposition copies for the court which is taken on record. Let a copy of the deposition be supplied on the land council for the state
along with the appeal memo.
Along with the appeal memo. The Mr. Naik.
Within 2 days, man.
Within 2 days for them. Have you filed your VNAMA, Mr. That is there?
Yes.
I've already entered appearance for the respondent. Put up this matter in the week commencing from 29th of January 2024.
May I pray, Lordship, that NBW has been issued.
My lord, in this case,
adding the petitioner.
What is the offense here?
My lord,
Offense 307 along with the other alleged offences.
All right.
petitioner is named in the FIR, named in the 161.
That is to be adjudicated on that. NBW say, the bail only let that be stay of execution of NBW till next date. Yes.
Item 24.
24 Lordship, I file an IA.
Appeal memo.
Or
Yes, item number 24.
24 file an IA for entry bill on the ground of mother's death मिला.
आनिले की कौन?
हाँ, Friday I will short copy. And today also I will short copy Mr. Mishra. आपने शुक्र अपन देख
Tomorrow let it be taken.
19th lordship funeral ceremony 19th.
19 रे कौन अछि?
10 ता नाम
बोधे माँ मरी जाइछि तो कहला कौन?
कॉपी शुक्र को भाईना गोटे देछु आ टुडे भी गोटे कॉपी देछु मिस्टर मिश्रा
से आकु काउ कुआइतला फास्ट आवर आनिया पई तांगु जे इंस्ट्रक्शन आलान वेयर इज मिस्टर मिश्रा
Tomorrow.
ओके ओके एरो खाली की नहीं आसु प्लीज दिस मैटर टुमारो खाली कर दियंतु आज स्प्रेड फॉर बाय द लर्निंग काउंसिल फॉर द स्टेट एटा आगु दस्तखत करनी पड़ी दियो हां सब नेक्स्ट এটা তো হয়ে যাইছে
all prayer after tomorrow first
কালি তো
tomorrow my lord